comment? Did we wear everybody out? There we go. Please introduce yourself.
Mr. Chairman, members of the committee, my name is Donna Sheen, and I'm the director of the Wyoming Children's Law Center. Our center has represented many of the youth and families who've experienced suspensions and expulsions across the state. I want to start by just reminding everyone that most school discipline problems are really typical, normal adolescent behavior, and they've been occurring for as far back as we can remember. It's an age where kids both test limits and also learn limits as well. So part of what I hope we start thinking about is both how to normalize it and then what our response should be in order to give them the best chance of learning from the experience. Oftentimes, these are kids that these are an opportunity to identify a mental health issue that maybe previously we've been unaware of. The second thing is, I think it's important to note that there is really no research out there that shows any kind of school safety, overall school safety benefit through the use of exclusionary out of school discipline. And in fact, there is a lot of concern about what happens to these youth when they are out of school, especially for long periods of time, a year-long expulsion. And a lot of research that shows that these are kids who are typically going to be more likely to be involved in a criminal justice or youth justice system because of that. Because, I mean, just leaving kids without a place to go during the day where they're feeling isolated and rejected is never a good strategy for really changing behavior. And there was mentioned zero tolerance policies. I also wanted to talk a little bit about that because I think we've come to realize too that that approach was really not very effective. It just doesn't make sense to consequence the young man who forgets his hunting rifle in the vehicle the same as we might for a student who brought a gun to school because they were feeling threatened by somebody who had scared or bullied or harassed them. In fact, as one of the earlier education folks talked about, these situations are rarely cut and dried. There is generally not a pure victim and a pure perpetrator. There are some times, but a lot of the times, as you dig into the nuances of the situation, there is far more involvement of other students, of a dynamic within the school that takes a much more seasoned response. So I always like to talk about two sayings that I think are really important in my work. One of them is hurting people hurt people, which means when a lot of these kids are acting out, it's because they have some kind of harm or trauma in their background. And that all behavior is communication. And we really have to pay more attention to what those children are communicating with their behavior in order to choose an appropriate response that's going to change and minimize the chance of them becoming long-term problems for our system. Kids who don't graduate, who have poor education and work outcomes, who struggle then to even make a living. So as you know, I sent you an email suggesting a couple of things that I would hope the committee will consider. The first is to really look at the language of what behaviors can warrant suspension or expulsion, because it is very broad and it's not clear whether, for example, a behavior that a board of trustees thinks is clearly detrimental to the education and so forth, whether that warrants a year of suspension or a day of suspension. And so what we see when I represent families is there are some very extreme examples of situations where a family is going to be facing a year of expulsion. For example, for a child who forgot a knife in their backpack and then it was discovered at school, and having to deal with what they're going to do then with that child, especially if it's a younger child that really shouldn't be left at home alone, and these are working parents. We talked about having all these alternatives, placements when a child is really acting out. It may warrant a placement at a BOCES or something like that. But suspension and expulsion interrupts that consideration because they're just simply left oftentimes without services. Now, not always, and I recognize that some schools are doing a much better job than others. So the second part of the recommendation that I made was that we really need to gather that basic data and be able to analyze it for each school district, both for each of them to compare themselves with the other and be able to identify successful strategies that one school might be using that might be important. I think also the Department of Education, asking them to put together maybe a best practice guidance for the school districts on when and how to impose any kind of suspension on a youth. But nationally, I mean, it's really become recognized that when you are going to use suspension, it makes the most sense for it to be in-school suspension in some way, shape, or form, whether it's an alternative day school or a residential placement, so that that youth is still receiving the educational services and still able to make progress and hopefully improve and turn around whatever behavior got them into that situation in the first place. And I also provided some handouts. The first two really just spoke to some of the data on suspension and expulsion and why it is important to really use what we know now of the research. I think before we knew a lot of what we know now about mental health interventions and behavior specialists and how much they can be utilized to change youth behavior. Suspension and expulsion was sort of our only tool in the toolbox. But now that we have so many others, I think it really is time to direct schools to use this blunt instrument less and use the more effective strategies that we know really help kids. I also provided you just with a couple of handouts that talked about school pushout and what that is, because oftentimes there are attitudes and beliefs that prejudice some decision makers or those who are reporting or even viewing what's happening. You know, they do it through a lens of some kind of a bias. And so oftentimes we see that even though there may not be an intent to discriminate, that in fact children with disabilities, especially in Wyoming, are far more likely to have that school discipline imposed. And that's nationally a phenomenon too that people are trying to address, as well as we see a lot of racial disparities depending on the school and the school district that indicate that there is maybe not an objective way to implement suspension and expulsion. And I think a lot of that goes back to the definition is so broad that I can honestly tell you that even though there is a due process, a chance for a hearing and a chance to take it to the court, I, as an attorney in my 15 years of practice doing this kind of work, have never found a successful way to challenge that, because it's, you know, any behavior which in the judgment of a local board of trustees, so that sort of gives them broad discretion to decide what, in their opinion, is an offense. And so then where does that leave a court? But to say, well, if they decided it, they're allowed to decide it, and therefore they're allowed to impose it. Finally, I did provide you with a handout, though, that I think gives a good example of a strategy that Utah just implemented. It's school safety amendments that they made that develop some reporting requirements and also some guidance on ways to improve school districts' uniform response to problems so that they have a better chance of identifying effective strategies to make schools as safe as possible. And with that, I would stand for any questions.
Okay, questions from the committee? Yes, go ahead.
Thank you. Just briefly. So I think maybe a way of framing this too is there are two issues we're looking at. One, we're asking ourselves who is getting expelled. But I think the other piece that's missing from your testimony is who's not getting suspended, expelled, or disciplined. And so I'm just wondering if you want to opine on maybe that second question, because I think that's what we're grappling with today. And honestly, coming into the hearing, I was focused on inaction and less on this, though here we are today talking about all of it, and I've been thinking about it too for a while. So do you want to opine on that other half of what we've been discussing?
Mr. Chairman, Senator Ellis, yes, and thank you. I meant to touch on that a little bit more. I do think it is a difficult balance, and there are a lot of other players. So a lot of what you were describing probably have some components that are outside the school district's control, because you described some criminal behavior that should have been maybe perhaps turned over to law enforcement for them to investigate and take action. As far as the school discipline piece of it, though, goes, I think there is still opportunity for the school to do the right thing in terms of separating, protecting an alleged victim while they do an investigation and things like that, where certainly there could be some clarity. And I do think that the Utah bill addresses that too, because part of their concern was that situations of bullying and where victims are maybe left in vulnerable situations isn't addressed. And so gathering the information about that, how many complaints were made, what discipline occurred because of that is also going to be important to know, because then you might be able to identify a problem, especially in a certain school district where certain individuals get away with things and others don't.
So, Mr. Chairman, to follow up, and I know you practice law, so this is, I think, an area where you might have more insight. When a student, breaks the law and on school grounds, because that's what I was talking about here. This wasn't things that happened remotely. These happened and were reported to school district officials. You have your criminal process where your burden of proof is high, beyond reasonable doubt. But on the college campuses, for example, if you have a sexual assault and maybe a student who might be expelled from a university, they have separate processes that don't necessarily require that high level, because you're not taking away that person's life or liberty, you're just expelling them from school. So can you talk a little bit about what you've seen the districts use? Because I don't think they're using beyond reasonable doubt. Did the sexual assault occur on school property? I think the burden's lower. And just kind of walk us through what you see happening out there and how districts handle those kind of adjudications for kids.
Representative Paxton. Senator Ellis, yes, that is true, but I do think for the most part, using the processes that are in place under some of the federal laws, Title IX, the civil rights complaints that you can make through OCR are usually fairly effective. It is hard because I think school districts are bound by confidentiality, and I've certainly been representing parents on the other end who their child was facing a lot of unsubstantiated allegations, and of course, that's a difficult thing to combat because you're not going to want to say it was my son and he said this, or, so it presents a difficult challenge for schools, but I do think that the Title IX regulations for the most part are fairly effective, especially in reporting sexual harassment or any kind of sexual misconduct and having that investigated. Now, whether some schools do it better than others, I would definitely say that we've seen some differences in terms of how well they're trained in that. And I think that, again, having maybe some, from the Department of Ed's perspective, having them maybe establish more concrete resources and investigation processes and support might also benefit that so that it can be addressed more effectively.
Go ahead.
Just to follow up, so let's take it out of the sexual harassment, sexual assault context. A student brings a weapon to school, nobody from the district sees it, but another student reports it. The kid hears that he got reported, or she, whoever. Both students, then it's a he, you know, he said, she said. And so how does the district, that's what I'm trying to get after, is what kind of discussions, because you represent families, when you are listening to boards make these determinations and district officials, I'm trying to understand kind of what level of, or how they get to their decision-making on some of that kind of stuff.
Representative Paxton, Senator Ellis, I think I don't have a really good answer in terms of how they should do it. I can tell you that for the most part, in conflicts like that, where there is maybe no clear truth that can be ferreted out, that you're, you're left with two people who seem fairly credible saying two different things, that probably better strategies that schools should use are restorative justice models, for example, or some kind of a restorative process where you can help these youth who are in conflict maybe find a resolution themselves so that it doesn't carry forward, because oftentimes that's the beginning of something else where there will be more and more tension maybe between these two kids and more problems cropping up. But again, I think the adversarial system that we sort of superimposed on schools because we felt like that worked well doesn't really work for kids, because they're in a different stage of growth and adolescent development. They need to learn lessons, certainly. They need to be held accountable in appropriate ways, but they need opportunities to learn from it too. So having a structured process where that conflict resolution happens is also very effective.
Okay. All right. Anyway, yes, Representative Conley.
Thank you, Mr. Chairman, and thank you, Ms. Sheen. And while I know that you need to maintain relations with the districts, right, I am curious from your experience, because you represent parents and kids in these proceedings, if you've seen differences among or between our districts that do discipline better than others. So for example, we heard from Laramie County with 14,000 kids and Meeteetse with 110. Right, and with 110, you go knock on the door, right, of the parents. And then with Laramie County, we saw this multi-tiered system of support that seems to get implemented when there's an issue. And I'm just curious if you could give us your insight from your activity in these proceedings.
Go ahead.
Chairman Paxton, Representative Conley, I do see differences. We certainly don't have cases with every district, and I wouldn't want to name one versus the other. I do think the resources of the very large districts mean that they often have access. If you come in, me as an attorney with a parent I'm representing, if we come in and say, we have a concern here and we would like to see you bring in an expert, maybe a behavior specialist to help with that, they find that usually a little easier because they're big and they've probably got those resources in-house, versus small districts, I think, really struggle with that. So one of the things that I've wished on my wish list for years is that the State Department of Education put together sort of some kind of a resource bank of ways that small districts can reach out and get some support, because it's just not possible to have that many levels of expertise when you're that small.
Okay, anyone else? Okay, thank you.
Thank you, Mr. Chairman.
Do we have anyone else who would like to give public testimony? Don't be shy.
Chairman Paxton and Committee, I'm Teresa Chalk, Superintendent, Lincoln County School District Number 1. I just wanted two things I think I kept hearing was like the FERPA, the Family Education Right to Privacy Act, does come into play with any discipline action that we have. And then the immediacy for like a sexual assault, if it becomes Title IX, I know parents want immediate action. We can't do immediate action. Title IX strictly tells us that if we have an assault or a sexual act committed, we have to treat both parties the same until we've completed that investigation. So if I think that person A really did assault person B sexually, I have to separate them both. They have to have the same consequences because we're not allowed to punish that person before we've completed the investigation. And I just think it's very important that Title IX has stipulated that very specifically, and I just wanted to make sure you guys had that information.
Okay,
That's all I have.
go ahead.
Mr. Chairman, I'm sorry, I didn't catch who you are.
I'm Teresa Chalk, Superintendent in Lincoln 1.
Lincoln. Okay, thank you.
That's all I wanted to share.
Thank you, appreciate it. Anyone else like to testify? Okay. Committee. We're down to committee directives. Do we have any? Yes.
Mr. Chairman, I would like to have this stay on our agenda, and I have at least one idea, if not two. And one of them I actually sent up to the committee, and actually I didn't even realize Machine would answer the question that I just asked in that way. But that it seems to me that we want to reduce the number of suspensions and expulsions in order to retain kids in the best possible way. And again, I want to go back to, I totally understand that there are times we want those kids out of the classroom. We just do, for a period of time. But we do understand that there are direct consequences to kids not being in school. We also understand that the WDE does not provide professional development or technical support to districts in this regard, with the exception of for kids who are under the IDEA. So I looked at our statute and I saw that we, as the legislature, added a few years ago an obligation of the WDE to develop protocols for seclusion and restraint, just so that districts could come in and look at them. There was no obligation for them to adopt them, but it required the WDE to provide that kind of technical assistance to districts when asked. So my suggestion would be a bill draft that would modify in its 21-2-202 a new section that would have the WDE, or actually it's the superintendent, to assist local school districts in suspension and expulsion, to develop model protocols for the use of suspension and expulsion as a disciplinary measure for all students. These protocols shall be designed to maximize student retention and success, and no district shall be required to adopt as any part of these model protocols. So that's an idea for draft language so that we can continue this discussion next meeting.
Okay,
Second.
That's in the form of a motion?
Yep.
Okay, and a second from Senator Ellis. Discussion from the committee.
Just a question, Mr. Chairman.
Go ahead.
So, Mr. Chairman, thank you. I guess my question is, I would assume all districts are doing this. If we're not going to require it, then are we doing busy work of, and I don't mind the bill draft because we can debate this. But I think the question I would have in the end, are we doing anything substantive Or are we just giving a workload to WDE and districts are already doing this in another form, in another way?
Mr. Chairman, if I could respond, I think that's a really good question, and it's in part why I want to continue the discussion. I don't want more busy work. I was part of the group that had us reduce the number of reports, for example. However, that being said, we added it for seclusion and restraint. I want to know that at our next meeting, has it worked, having protocols at the WDE that districts don't need to adopt? Let's find out how that worked. I think that it could be valuable in part from hearing from Mr. Farley, I forget his name. Okay, from Laramie County, who said, you know what? We go out and help others when asked. I think that is admirable that Laramie County does that, but maybe our WDE should really be the repository rather than the goodwill of one district. That's why I want to continue the discussion.
Okay. Anyone else on the committee? Question's been called. All in favor signify by saying aye.
Aye.
All opposed, no. Motion is carried. You might want to make sure it's shared set with Tanya so you get it, everything the way, okay, good.
Mr. Chairman, I think part of the solution of what we've been talking about, we're going to hit when we talk about the next item on the agenda in the BOCES. I think there's some things in there that, with regard to some of the out-of-school placement, we'll get into and that'll be quite important. So just serve notice in the committee that there's a tie-in there. And then, Mr. Chairman, we have in our packet the School Safety and Climate Act amendments, previously sponsored by Senator Ellis. Are we going to deal with those, Mr. Chairman?
That's where we are right now. We're ready to deal with that. So with that, Senator.
Chairman,
Oh,
Before we
yes,
go on,
sure.
I'm wondering if we, or the committee chairs, could make a request to the WDE that at our next meeting, we get some information about the possibility of including more reporting requirements that are not burdensome. All right, and I want to emphasize, not burdensome to districts, so that we can understand more about the data regarding suspensions and expulsions. Because again, we're only getting kind of the tip of the iceberg. And so I'd like to understand where we could increase that reporting.
So did you get that? All right. Shaking your head, yes. Yes, go ahead.
Mr. Chairman, I think we need to be pretty careful in this area. It's one thing to do some specific reporting or report on a particular issue on a time-limited basis. But if we don't limit it that way, we're going to just put an increasing administrative burden on the districts. It's going to distract from the classroom teachers getting their work done, and it's going to be expensive and not be used. So my instinct is we've already got too much reporting. And if we just look at it as a data problem, I'm afraid that's a substitute for doing something about it.
Yeah. Mr. Chairman,
Representative Conley.
I'm going to absolutely agree with you, Mr. Co-Chairman, but I do know that the districts need to report to the OCR, but they don't then forward that to the WDE. So again, I would want to emphasize limited, if any, burden at all to districts. And I'll add another problem I don't want to get into is the unique identifier of kids, right? I don't think that we should be keeping that. And so I think that I'm asking for some real kind of thoughtfulness in terms of the possibility of collecting data that meets both of those, if not more, criteria.
Okay, thank you. Anything else? Yes.
Before we leave the topic of crime and punishment with regard to K-12 education, I had sent you all an email this morning regarding corporal punishment. It was brought to my attention that it's still on the books in Wyoming, although most school districts, to my knowledge, have local policies against it. I would like to do a bill draft if the committee would approve of the bill draft idea to go ahead and go into 21-4-308 and just eliminate it from the books completely here in Wyoming. And I would probably be just deleting subsection B. And just curious to start that conversation, make it a formal motion.
Second.
And then hear what your thoughts are.
Okay, it was a motion seconded by Brown. Any discussion from the committee? Yes.
I'll just say that I certainly will support the motion. I had thought that we'd taken that off the books entirely quite a number of years ago, and it turns out that isn't the case. I appreciate bringing that forward, and we can remedy that through a good little bill. Thanks for that.
Any other comments from the committee? Discussion from the committee? All right, sensing you're ready to vote, all in favor signify by saying aye. Aye. All opposed, nay. Motion's carried. Henny, you got all that? Okay, we're good. All right, anything else in the way of committee directives? Oh,
Okay. Thank you. Thank you, Mr. Chairman. If you, I don't know if that's your invitation to start talking about the two bills that I've got presented to the committee right now, but we'll start going down that path. Committee members, I sent you, as you mentioned, as you know, this packet of news articles that I've kind of been compiling over the last 18 months or so that really talk about mounting frustration among students and parents when they complain to their school board members, their district administrators about a variety of things. We've touched on a lot of them already in our discussion this morning. 30 victims at a small high school who were blackmailed into and asked to provide nude images of themselves. What was the district's response? Students who were victims of sexual assaults, reporting that to their districts, and a perception that nothing happened and that the district failed to act. And so, these just aren't articles in our newspaper. These are people that live in our communities, and certainly one that affected me this last year pretty significantly involved a football coach and some really egregious behavior. And I don't want to get into the specifics because if I did, it would really out the identity of the students who complained. But in essence, very extreme behavior. And I want to at the outset just dislodge any notion that these are snowflake kids who can't handle football. When I heard these complaints, I was sick to my stomach. No kid should be treated that way. So I wrote a letter to our superintendent and our school board members, and I was trying to better understand what the process is for how a complaint would be handled. Some of the students and their parents filed complaints with our district, and they would ask me what's going on with them. And I said, well, I don't know. I'm trying to understand the process. Ultimately, the coach, to my understanding, was contacted by the district, and unfortunately, there were students who were retaliated against. And the district was very hush-hush about it until I started getting a phone call to participate in interviews for their investigation. And I said, well, I didn't even know there was an investigation. So it wasn't even that they asked for my feedback. It was more they wanted the names of the people who had reached out to me so that they could contact them for their investigation. So long story short, Mr. Chairman, as I started looking at this issue, there were a number of things that became apparent to me. And I visited with our good chairman on the Senate side about this. And I recognize that under our Wyoming Public Records Act, we have a duty to maintain certain things as private and confidential. And that's an important thing for us to maintain. But to the extent that it starts involving children, the safety of children, the well-being of children, I just think that we maybe don't have that balance completely right. So you'll see before you 23 LSO 77, draft number 1. And I want to be clear with the committee, I do not want to take action on either of these bills today, but just wanted to make them known what they would do, get more feedback, visit with your constituents, and then maybe we could take them up at our next meeting. But this would amend the Wyoming Public Records Act. Right now, personnel files are not considered public records. And the problem with that is that's been litigated in a few instances, most notably with the president of the University of Wyoming when she was dismissed several years ago. But this bill really is seeking to try and find a way for parents who are concerned about the safety of their children to have access to files when a complaint has been filed, an investigation has been done, and as long as that activity is related to what happened with the student. It's not intended to open this up to all public employees, and it's not intended to open up the entire file. But in doing research on this, there really is no definition of what constitutes a public or a personnel file. I think generally it's understood that social security information, your home address, those kind of things, performance reviews, those should be protected. But we're trying to get after those parts of a person's personnel file within a school district when they have conduct that impacts students. In my own example, I did hear from some families in Colorado. This coach had coached down there, and there were similar concerns. And so that's my concern, Mr. Chairman, is that perhaps our districts don't even know that they're hiring people with these things in their personnel files, and yet we're handing them, our kids off to these individuals. So that's the intent and the purpose of 64203. And then the second one has to do, this is 23 LSO 0078. And this has to do with the Safe School and Climate Act amendments. As I was doing research on what the process is for bullying, which we passed a number of years ago before I was in the legislature, it was clear that all of our anti-bullying statutes are really geared toward the mindset that it's student on student. And so a lot of the bullying policies that I think Laramie County 1 has changed some of their protocols since then. But really, when you read the language, it was assuming that we're talking about bullying with students on students. So what this bill would seek to do would be to make it clear that this bullying can occur from school district employees to students and vice versa. And just laying out a process of what that would mean and just making that clear that those protocols that we just heard so much about and that are effective go both ways, particularly when you have this imbalance of power of a teacher who can control grades over a student. The other thing it would do would be on page 3. You'll see that there's mention that formal, and this is talking about school districts coming up with their policies. Right now, there's a prohibition that said formal disciplinary action shall not be taken solely on the basis of an anonymous report. And so it would just clarify that by striking that it doesn't matter that if a district receives information anonymously, if the district receives an anonymous report, does an investigation that substantiates the claim, then that person who's the subject of the investigation should be held accountable with any kind of disciplinary action that's appropriate. So like I said, Mr. Chairman, that's the purpose of these bills. I think they do need some more thought and more work, but I wanted to just kind of piggyback off the discussion we had today, that I don't think the governance issues that we're having with school districts just applies to student-on-student conduct. I think we have instances where we need to do a better job of looking out for the safety of our kids. Thank you.
Okay. Questions or comments from the committee concerning these bills?
Mr. Chairman,
Yes.
I think we're starting down a road that we need to go down, but it's going to be very difficult to get down it because we have a balance between protecting people's privacy, keeping unfounded allegations from getting out into the general public and doing considerable damage when somebody's falsely accused. And we need to also, though, be able to communicate with the public that when there is a real concern there and they're seeing it's adversely affecting their kids and whatnot, that the school district is in fact doing something real about it. And I think striking that balance is going to be pretty difficult, Mr. Chairman. I don't think we're in balance now. I think we've gone way too far on the side of secrecy. These bills, Mr. Chairman, in my judgment, are a good step. I would hope we would carry at least one, maybe both of them forward to the session as committee bills. But I do think we're really opening probably a multi-session inquiry before we get the problem entirely solved, because it is going to be a difficult balance to strike. So, Mr. Chairman, I hope we would consider them at our next meeting and think about carrying one or more of them forward to the session.
Yes, go ahead.
Mr. Chairman, if I could add, I think the good senator's right. What ended up happening was parents were frustrated at a lack of what they perceived to be process. So their outlet was to go to the media, and then it started turning into a media battle, which is a disservice to this very employee. And, you know, on the back end of this all happened last year. I've already been getting phone calls again this year, and I've said, well, you need to file a complaint. And I can tell you parents say, I don't trust the system. I don't trust this. My kid's going to be retaliated against. I have no faith in this. And it goes beyond just this one instance that I highlight in the article. I've heard from a girl who felt that her dance coach fat shamed her. I mean, hours of my life, I've been hearing, people have called to tell me their stories, and we need to figure out a better process and figure that out so that parents and students have confidence in these institutions. Because if not, it trickles up to us and we hear about it, because this is very real.
Mr. Co-Chair?
Mr. Chairman, and also we heard not only from parent group, but from the military commanders at the air base here. And they were concerned that some incidents against some of their soldiers, kids, were not being taken seriously. And those are dead serious allegations and could have bad consequences for the state. And it turned out the district had been doing things, but they'd been scared to tell anybody. And so the Air Force people were getting the impression they're just being ignored. This is a dead serious issue, Mr. Chairman. And we're hearing about it from some people who have very serious concerns, could quite a bit of harm to the state if we don't get it fixed.
Okay, further comments? Yes.
Just briefly, I appreciate Senator bringing this forward, and I'll be honest with you. While she works in the triad that she represents and has been hearing this, I've been working in the triad that I represent in the capital city, dealing with very similar accusations. And this is, I'll be honest with you, seeing this as the first piece of legislation, whether or not we move this through, that's fine, but this discussion has to happen. We are expecting our children to go to high school, go to their elementary school and junior high school, and we expect these teachers, coaches, administrators to have compassion and a level head when they walk in with our students, and unfortunately, that is not occurring. I will tell you, I've had good response from our school district here. I've been working with them, again, as the Senator just mentioned, I was working on this last year at the end of the year, and as soon as school came in this year, I've been dealing with the exact same thing all over again at the start of this year. That tells me that we have a systemic problem, and we really need to address this. So I appreciate the good Senator bringing this forward. I can assure this entire committee and everybody here that we are not the only school district that this is occurring in either. So this is the perfect place for this committee to take action and fix this for the state. So thank you.
Okay, other comments? Yes.
And I'm just curious about the bill draft that we have in front of us that came in our packet, which is 23 LSO 78. And really, to me, all it does is define person to include students, school or district employees, administrators, or volunteers. So I'm curious how the bringer believes that changes what's going on right now. Is it that person isn't including all of these, only includes other students? So I really am curious about how this bill draft attempts to solve the very real problem that you're talking about.
Senator Ellis?
Thank you, Mr. Chairman. So there's a lot of layers I've been thinking about, down to, do we have like the model bill that says, here's a protocol for how districts should handle certain complaints, and at what stage are things public and what are they not? And that's really difficult to do without making choices for 48 school districts on what that protocol should look like. So what this really seeks to do is just amend that part of the Wyoming Public Records Act that defines personnel file, which is right now exempt from being available to the public. It's intended to just loop in persons that work for a school district and have contact with students. So if they're the subject of an investigation, and this needs a little work, I'll admit this needs work, but at what point, when they've done that investigation about the conduct that involves children, should the public have a right, through an ombudsman, to make sure we're protecting the identity of kids, have a right to know, so that parents can at least see that the claims were, and students, that the claims were investigated, and here's the outcome of what happened. And that's something I think that's been lacking, because it just gets stuck in a personnel file.
Representative, through the chair.
Mr. Chairman, sorry, Senator, I was talking about 78. And 78 is simply this addition of language to define person. And I was curious about this particular bill and how it addressed the problem, not the bill that you were just talking about.
Mr. Chairman?
Yes, go ahead.
Mr. Chairman, so if you look on 21, on the first page, under 21-4-313, prohibition against harassment, intimidation, or bullying, and reporting to school officials. So this says no person, which if you read the rest of the policy, and if you look at a lot of our school district policies, assumes that we're talking about student-on-student bullying. So this seems, is seeking to say that no person, which includes, but isn't limited to students, maybe this needs some more wordsmithing too. It includes students, school district employees, administrator, or volunteers. That bullying can occur between those different classes of people.
So, Mr. Chairman, just as a follow-up, so you're saying that when read in context to the other portions of the chapter, person only includes a student, not these other individuals or groups?
Mr. Chairman, ask LSO if we need some wordsmithing to alleviate what Representative Connolly is asking about. Do you have any thoughts?
Mr. Chairman, Representative Connolly, Senator Ellis is exactly right. In practice, I think there's a varying occurrence across the state about what no person means. To your point, we had this very discussion with an LSO about the term no person. And this just seeks to clarify in the event there are districts that do not have the power structure bullying provisions that were discussed earlier, where it's involving a teacher versus a student, or even teacher on teacher harassment and bullying, that this Safe School and Climate Act does apply to those.
Okay, yes.
The other thing that I think is important is this bill does do more than just changing that definition. And I think in my mind, the biggest portion of it is on page 3, lines 10 through 12 get struck, and that's the formal proceedings and the formal disciplinary action on an anonymous basis. I think that's huge. And then, of course, on the last page, the significant contact. And I think this is also a major issue because what I've been dealing with and with some of my constituents and some of the issues that I've been seeing is these are coaches and or assistant coaches that are dealing with the students after school that may see them for 20, 30 minutes. And that's when the bullying occurs, but then they're not around them for the rest of the day. So striking this significant contact really does put it into perspective that this can be an issue that is not just somebody that's a teacher that sees them for an hour and a half a day or 45 minutes a day, that this is anybody who has contact with that. So I want to make sure that, you know, anybody who's listening to this understands that we're not just going in and opening up the person statute and putting that in there a little bit more, that there's far more to this bill. And I think, again, I appreciate the senator bringing this forward because to me, the anonymous reporting should be capable of having, you know, we should have people be able to make an anonymous report and have it be justified and not have to worry about, you know, facing the accuser and or whatnot. So.
Okay, for the question, yes.
Mr. Chairman, thank you. On the 77 draft, you know, I'm going to be honest, I worry that we're pulling out basically school district personnel out of a subset of people, state employees that could in fact deal with children, DFS workers, you name it, right? So I'm not really comfortable with this language and wonder why you're choosing just school district personnel as opposed to any state employees or school district personnel that deal with children. You know, I think it's pulling them out specific when they're not the only individuals that deal with children that are state employees.
Senator Ellis?
Thank you, Mr. Chairman. I think if we do that, it kills it. I haven't heard from constituents saying that there's a DFS worker who works with kids that is somehow doing something bad. I haven't heard one. I have heard from parents and students who said this school district person who interacts with my child has been engaged in some wrongdoing and some harmful behavior. That's why it's limited to that. And keep in mind, these are drafts. lots, I do acknowledge, I think more work needs to go into these, but I wanted to really get the conversation going. So I can appreciate that, but I think that I'm responding to the concerns I've heard from my constituents.
And as an education committee, we probably ought to stay in our lane.
Mr. Chairman,
Yes, go ahead.
move we carry these two bills forward to the next meeting.
Okay. Move that we carry the two bills forward to the next meeting. We'll have public comment afterwards. All in favor signify by saying aye.
Aye.
No? That we carry them forward? Yeah, because we're not passing them to.
Right, but we had comment on them?
Yeah.
That would inform my vote on this.
All right, well, then we'll take public comment right now.
Mr. Chairman, members of the committee, I'm Grady Hutcherson, second grade teacher with 24 years of experience teaching in the classroom in Wyoming. I also serve as the president of the Wyoming Education Association, and I also was appointed by the governor to serve as a commissioner on the Education Commission of the states. And I know testimony needs to be short and brief, and I want to stick to the points, but I also want to start by telling you this is my favorite time of year, back to school. It sends tingles up my spine every year. It continues to. And the reason I mention my position as a commissioner that the governor appointed, we recently this summer attended a policy institute in Washington, D.C. And you all are aware of the national crisis related to teacher and school employee shortages. And one of the reoccurring themes that I wanted to share with you all related to these, especially these difficult and challenging policies where Senator Scott mentioned that finding that balance, is also really thinking about making policy decisions that show and demonstrate respect and elevation of the teaching and education profession. And so I wanted to bring that forward to all of you as part of the consideration as we move forward with any policy decisions, because I can tell you, and I appreciate the fact that these are early draft versions, right? But I also have worried my entire career as a male second grade teacher that all it would take to destroy my career would be one false allegation. That's all it would take. And it still scares me. And then I worry that with this initial draft bill, now that false accusation can then just be moved to the press regardless of what the outcomes of any investigation would have been. So it is a sensitive and complicated issue, and I just wanted to bring that forward. And I also wanted to share one other quick point, because I had the distinct and unique opportunity on the first of the month to attend the White House Back to School event, which was a wonderful celebration. And I bring it up because of some of the earlier conversations. The Education Secretary Cardona has really a focus on intentional collaboration. And the example he used was with Secretary Becerra from the Human and Health Services, and how those two agencies can be working together to address things like mental health needs of students. And so I thought it was really exciting, and I know some of that conversation had been mentioned during the discipline, suspension, and expulsion topic. So I wanted to bring those thoughts forward to you, and I also want to extend the invitation to please know that I'm happy to work with any and all of you as we move forward with these important policy decisions. Thank you very much.
Okay, questions or comments from the committee? All right, thank you. Other
Mr.
public
Chairman?
Comment.
Oh, sorry.
Go ahead.
Mr. Chairman, members of the committee, my name is Tate Mullen. I'm the Government Relations Director for the Wyoming Education Association. I want to echo President Hutcherson's comments. I appreciate that these bills are in early form, and again, extend the invitation to the bringer of these bills to work together on this. But we do have some substantial concerns with the bill draft as is. I'm going to run through a number of these, and these are potentially some opportunities to where we could collaborate. First and foremost, there is some vagueness in the language, as in reference to 23 LSO 77. So what constitutes an investigation? What is substantiated? Disciplinary proceedings or professional misconduct. We have some substantial concerns about vagueness of language here. Where are those definitions found? We need to flush those out. This bill also makes a public record of all documents involved with the continuing contract suspension, dismissal, or termination public. That is unnecessary and potentially creates both legal and practical problems. Under current law, continuing contract suspension, dismissal, or terminations are ultimately decided by the board, who makes specific findings of fact and conclusions of law, fully explaining what happened and why they decided the way that they did. Releasing everything creates major problems. So, for example, the record will contain a list of exhibits, or sometimes actual exhibits which were not admitted into evidence. In some cases, there are motions to prevent the introduction of irrelevant, illegal, or otherwise problematic exhibits which weren't admitted. Regarding continuing contract teachers, it provides for publication of all documents, even in situations where the employee was exonerated. All right, so what happens in the real world is people hear the accusation but don't accept the exoneration because it's easier to gossip about the allegation. So again, to President Hutcherson's point. There may be student records where the name might be redacted, but by context, others can figure out who that student may be. That's going to be really tricky in some circumstances. This is going to create a major administrative burden in trying to decide what must be made public and not, and can result in situations where the issue has been handled to the satisfaction of parents, but gets blown out of proportion when somebody who has an axe to grind, whether that's an individual or a group, gets a hold of this information. There is the potential of a chilling effect. As an organization who deals with a lot of these situations across the state in a number of districts, I can't tell you how many times our UNISERV directors have had to really work with people to try to get them to come forward because they're concerned that there's going to be retaliation either by parents or by administrators. So there may be a potential chilling effect that is caused by this. There are potential questions about how this bill interfaces with federal law. All right, so Title IX has its own procedures and requirements about what may be released. The Office of Civil Rights has its own separate rules and procedures, and state law cannot override those. Federal civil rights law says that if the government is making statements that damage an employee's good name, reputation, or integrity, the employee is entitled to a full trial type hearing to contest the allegation. Similarly, if a school district were to release information just say on the basis of a conclusion by an administrator where the procedure of fairness is disputed, that would constitute a violation of due process and the district would be liable in federal civil rights litigation. Thus, making public record of every situation that arguably involves discipline of an employee will trigger a right to a trial type hearing, leading to dozens, if not more, of expensive hearings just because of this bill, as the language is right now. There are other types of unintended consequences. So administrators may hesitate to raise issues if they are not enough to start a formal termination proceeding. If they aren't careful, they could end up in a contested trial type hearing, possibly followed by a civil rights suit. The tendency will be not to document these issues, right? To avoid the legal complications arising because of statute like this. And at a time when Wyoming is trying to recruit teachers, it's not going to help to know that at any one time, again, to President Hutcherson's point, that any one allegation, whether credible or false, can destroy their career. There are a lot of unfounded allegations that we see as an organization across the state that are levied against our educators and support staff, even against the best teachers. An example would be, a situation where you have kids in a lunch line, right? And maybe the parent had a false understanding of what the definition of sexual touching was. And maybe there was a teacher who said, hey, I need you to turn around, keep the line moving. Student wasn't paying attention. So the teacher comes over, taps the student on the shoulder. That was what constituted the parent saying, well, you sexually touched my child. You go through the procedure, you go through the hearing, you find that no, that wasn't the case. But now the way this is written, at any point, that educator, if they go somewhere else, they're going to see that he was accused of sexual touching of a child, of a minor. Another example of unforeseen consequences is the effect on law governing initial contract teachers. Currently, districts cannot renew an initial contract teacher giving a reason, but so long as the reason is not made public, right? So that it's communicated to the teacher only. If that's done, they're not entitled to a hearing. However, it is settled federal law that if in relation to employment action against an employee, the government discloses information that could potentially damage the employee's good name and reputation, the employee must be given a hearing. The practical legal effect is to inadvertently give every initial contract teacher a hearing. And the legislature cannot preclude a hearing if they make allegations public through the Public Records Act, because the right to a hearing comes out of federal law. And the last point that I will make is I will echo the good Representative Summers' point. That it may be minimal, but there might be some equal protections issues here. Why are we singling out of every single government employee, educators only? You know, again, to his point, there are a number of, I know that we're hearing these claims from constituents, and we're hearing these concerns from constituents, but they are not the only people who deal with our children. DSF employees, we have a number of counselors, state counselors across the state. We have firemen, we have police officers. But those are the concerns that I extend the invitation to work with you all and work with the bringer on the bill. But there are some substantial concerns with this, the way that this is written. And with that, I will stand for any questions.
Yes, Co-Chairman Scott, go ahead.
Mr. Chairman, I would comment that this is an illustration of how difficult this bill is going to be to get right. It's going to take us a while. I think we need to get started because I don't think the current situation is satisfactory. The question I have specifically is the federal law involved that you've cited. Is that based on the 14th Amendment and their enforcement of the 14th Amendment, or is it tied up with our acceptance of federal money?
Mr. Chairman, Senator Scott, that is the substantive due process. That is the substantive due process piece that's tied in with that, within the federal legislation, within Title IX, as well as the federal civil rights statutes.
Mr. Chairman, I did not understand the answer.
Mr. Chairman, Senator Scott, it is not because we accept federal money. That is just the substantive due process piece. Federal legislation within the Federal Civil Rights Act.
Mr. Chairman,
You still look a little puzzled.
is it what part of the U.S. Constitution is it based on to give the feds that power?
What part of the U.S. Constitution
Yeah.
gives the feds that power? That would be the 14th Amendment.
Okay. Yes,
Mr. Chairman, just to push a little bit on some of those notions. I mean, equal protection protects against protected classes, race, gender. So we do this all the time. We distinguish between professions in our statutes. So I'm not as concerned about that. And then the other piece is the continuing contract. I knew that would come up. We've talked about it, LSO and I, whether or not we wanted to tackle it, and we don't. This is about public disclosure. And if I am going to give these educators, coaches, my children, I want to know if they have a history of abusive language toward children before I sign them up to play in certain sports. So by design, it didn't touch any of the continuing contract, initial contract statutes that are all found in Title 21. So I think we can tighten up definitely some of the adjudication steps, but this is the hard part. We just had a whole presentation about how processes work with investigations and substantiated claims and what's real and what's not. We had that discussion just a little bit ago. So these all work hand in hand. That's what your districts do right now. Was this kid serious when they brought a gun? Were they not? This is what you guys do, right? So I don't see this saying, you know, the tap on the shoulder, this is going to lead to termination. Maybe as a parent, if the tap on the shoulder amounts to something and I want to know, I don't want my kid around that person that taps them on the shoulder. I just think we're using some extreme examples. But at the end of the day, this is about notifying parents. So I have choices and say, I don't want my child to be with that particular individual in the classroom or on the athletic field.
Mr. Chairman, Senator Ellis, I appreciate the concerns, and they're legitimate concerns. We want to make sure that, you know, when we send our kids to school, we want to make sure that they're safe and that they're in good hands, right? So I appreciate the intent behind this, absolutely 100%. And again, would be willing to work with you on this. And yeah, I mean, that was an extreme example, but again, to the point, I think that we also need to be very careful that, to Senator Scott's point, that there is this balance, right? That we want to make sure that we are protecting our good educators and making sure that false allegations don't sully their name moving forward.
Yes, go ahead.
Mr. Chairman, then this is the scenario I want your answer on. Say you had a teacher who had a history of harassing students in another state, gets hired in one of our local school districts, exhibits that same behavior, nothing happens, another investigation happens. And so all of a sudden we've got like maybe 3 instances where you have something not great occurring. Right now, all I see is that can go in a personnel file and no one has a right to know. And so what's a better way of getting, as a parent, how am I going to know that that person has a repeated behavior of harassing students and children? How am I supposed to know that? Like, I'm trying to figure out what another way is to skin this cat, since we're going to use all of our favorite legislative phraseologies.
Mr. Chairman, Senator Ellis, I think that there are mechanisms. I can't give you specific ones right now. I know that there are other states that have passed legislation that have allowed, because there is a concern, right, that we want to make sure that we are hiring the best educators that don't have problematic pasts. So I think there are mechanisms available, and again, I'd be willing to work with you on that.
Yes, go ahead.
I will follow, I would like to see those, please. Thank you.
Absolutely.
Representative Conley.
Mr. Chairman, actually, this reminds me of the discussion we're having about police officers as well. Okay, so here's my question to you. I too, I'll start with, I too have problems with reading the language in 77 right now as well. I can think of a million different scenarios where you can have false allegations or an investigation that's unfounded. That being, and I don't want those, right? I don't want false allegations to mean somebody loses their job. I don't want a needed discipline to be reported in the press in a way that could ruin a career. That being said, do you have any problem with someone, a teacher, who has been subject to disciplinary, not just a procedure, but a disciplinary outcome, being a suspension, for example, that disciplinary outcome being available in the way that Senator Ellis is contemplating to the public? Not just the procedure, but an outcome. And that's the issue I have with the draft as it exists right now, because to me, it says that just the existence of a procedure can lead to public inspection. I want an outcome. If someone has been found with poor behavior in whatever it is, I'd want to know about it. So what do you think of that?
Mr. Chairman, Representative Conley, this is a couple of pieces here. This is where things get sticky, right? So what opens up the potential for those trial-like hearings, right, is any form of disposition, that whether it's termination, anything that's on the spectrum, whether that's termination, suspension, and sometimes districts enter into a confidentiality agreement, right, with that specific educator. So it gets incredibly sticky right there, and I don't have a solution that keeps, maybe an ombudsman, maybe there is the establishment of an ombudsman that helps us really kind of look through these and determine. And yeah, that gets real complicated real quick.
Well,
Mr. Chairman, I think this is getting at it, though. What if the one event isn't so egregious? It's like sexual harassment. What if it's little comments here, little comments there, and there's no ability to kind of compile those? And so, I mean, I'm struggling with this too. That's what I said. They're not ready for today. But I just want to add one thing. I would agree with you in that the biggest concern I have about this is it will encourage districts to not investigate at all. But I don't know what we're doing to protect our kids. And I've been hearing about it already this school year. And I don't know who you talked to on the phone, but I can tell you the parents I've talked to, the tears I've seen, the damage this has caused to children. from grown adults, and I don't know what to tell them. We've got to figure something out.
Mr. Co-Chair.
Mr. Chairman, and in figuring that out, I'm going to throw another complication in here. Now, teachers are human like all the rest of us, and we all make mistakes. And you want to have the district have some ability to give an individual who is otherwise has great promise as a teacher, the ability to make a mistake that isn't overwhelming, get corrected and learn from it. So we have to be careful in letting that be blown into a big public fuss when it was the correction for an honest mistake that you get corrected for, you learn, you don't do it again kind of thing. And drawing the line somewhere there. So that's, Mr. Chairman, that's what's going to make this a difficult subject to deal with.
Yes, Representative Rothfuss, or Senator Rothfuss.
Thank you, Mr. Chairman. The concern that I really have with this comes down to singling out educators specifically, when this is a problem that's rife throughout the system in terms of reporting and various violations and discretions going into a personnel file. We do see that with law enforcement, as Minority Leader Connolly mentioned, but we see that elsewhere also. Doctors, attorneys, I mean, really everything ends up being confidential. A lot of times, in fact, the way that problems are chronic problem makers are addressed is, well, let's just send them on to the next job and it becomes somebody else's problem. So we know that this happens. This happens everywhere. And the idea that it's appropriate for us to single out educators and carve out an exception in the Public Records Act to address it only here, but it wouldn't be appropriate to carve that same exception out for the governor's staff or for Department of Workforce Services or for all of our law enforcement agencies. That's the biggest concern I have, is the entire approach to this legislation. And I don't for a second disagree with any of the concerns that Senator Ellis is bringing up. And I know that they're real and they're valid and they're things that need to be addressed. And I share those concerns honestly for law enforcement and for other areas. If this is a problem that needs to be tackled in terms of the exclusion from public records of personnel records and files, then it's something that the Judiciary Committee needs to take on. It needs to be an interim topic, and they need to figure out how to create a universal appropriate exemption for where there is a chronic or habitual offender and they're being protected by their personnel records, and that needs to be publicized. That's the appropriate approach, and that's the appropriate legal framework. That's fair. And at that point, we're not doing what we often do, which is singling out educators as somehow being this evil force of malevolence, I guess, on our children, when that's not our intent. Our intent is to try and protect the kids that are in the system. Doing it inequitably, though, should not be something that we strive for. And that's why I have concern again with this legislation and even this motion. I don't want to move this bill along. I'll move the problem along, but I'm not going to support a motion to move this bill along. And as we have the motion on the table, I would simply ask that the motion be divided so that I can support moving the other bill along and not vote for this bill in any fashion, although I believe it's a worthy topic for the Judiciary Committee, or if we can come at it from an entirely different direction, I think that would be acceptable. But digging into the Public Records Act as a solution for this, boy, that scares me. Thank you.
Senator Salazar.
Thank you, Mr. Chairman. I guess, well, first of all, I'd like to agree with Representative Connolly. I agree with her suggestion that if there is a final disposition, and if after a great deal of scrutiny, a final decision was made of either some type of corrective measure for the individual and for his or her action, then I think that's something that, and especially if that individual was then to go to a different state, I think that's something we need to look at. I'm not making any judgment on the two bills before us, but I think this is a topic that we do need to address. The other thing is, and I respect the minority leader's opinion, but I think the whole reason this is relevant with regard to the education community is that we have our kids spending 8 hours a day at a school, and then perhaps even longer, 2 to 3 hours after that in sports. And so obviously, I think, and I'd like to see the statistics of where this occurs, but I'm assuming that a lot of this occurs at a place where our kids dwell. And then I guess my final point is, I've heard of such similar occurrences, and I think this is a topic that we do need to address. And I fully understand the constitutional arguments, and I agree with them. But I have a 14-year-old, and they need safe places. And currently, I think there are enough examples that I've heard just from the committee members that we can do better. So, thank you.
Okay, further questions for the current presenters? All right, well, we're not ready for that yet, I don't believe. Thank you. Further public comment? Anyone else want to make public comment? I knew you'd come up here sooner or later.
In Chairman Pax, members of the committee, I'm Kevin Mitchell, the Executive Director of the Wyoming Association of School Administrators, and I just want to ask some questions about someone that who would have to deal with this. So the practicality falls a long ways from you folks. So you make some of these rules, and I'm going to digress. Chairman Paxton, I want to talk about the student discipline as well, because I was thinking about the same thing there. I'm sitting in Powell, and I'm the superintendent. I'm not anymore, but I'll pretend like I still am. And I'm not exactly sure how I'm going to deal with this issue of anyone coming off the street and saying, the legislature passed a bill last year, and I have a right to look at anybody's personnel file that I want to. Because there's no accusation that I know of, unless they bring one saying Powell hired that football coach from the other district, and now I want to look at their personnel file. So there's a practicality issue of, what do you expect the superintendent to do with some of the ideas that you're throwing out here to protect everybody involved? And so not only teachers, but the entire staff that you work with, that's a little scary for me, being back in that chair going, yeah, here it is, go in that room and look at it. And by the way, it's confidential, you can't talk about it to anybody else in your family or your neighbor.
Chairman, this is not a characterization of what's in the bill. This is not what's in there.
I'm sorry, I misunderstood when we said that someone could ask to see the personnel file of someone that their child was going to be in front of.
I thought it was relevant.
Pardon?
Go ahead.
I misunderstood then, because I don't know how I'm going to be able to give that information to a public person. Either I read the file and say, well, here's what's in it, or I let them read that file. I don't know how else that would work.
Mr. Chairman?
Yes.
I think the bill says there has to be a claim, and then you have to start doing an investigation. And then in the process of that, some kind of investigation, like some kind of substantiated information, and then you would work with an ombudsman. So this isn't somebody coming off the street asking you to open a file. So that, I just want to be clear, there are steps leading up to releasing certain information.
Mr.
Well, go ahead.
Thanks, Mr. Chairman. What I understood the concern was is somebody could potentially be hired down the road, because this isn't necessarily something that would prohibit them from being hired again at some later point. Now I've got a personnel file where part of it, which is the previous circumstances, is a public record, and I'm, who are they asking for the public record? That's what I was taking from the testimony, is sort of how this actually plays out in real life. If they never get another job, I think problem solved. But on the off chance that they work again at some point, anybody off the street can come in and say, it's my understanding that there's a portion of this person's public record that is public and I'd like to see it. That's fair.
That was the way I understood the example you gave too from the
We'll keep going because I know I see the fatigue on my colleagues'
from the
faces.
coach who was hired out of state, from out of state. Okay, go ahead. Go ahead.
Mr.
proceed.
Chairman, and I think that's where I'm coming from. This is a really difficult situation from the person that has to fulfill these responsibilities. From following one set of rules, and then these kind of change those set of rules. So I just want you to think about that. I'm not saying what Senator Ellis is asking about is wrong, and children were not treated fairly at all. I'm not saying that at all. I'm just saying that you got to think about who's going to fulfill the responsibilities of what you're expecting them to do. And so I want to tag back on the student one as well. So we're saying at some point in time, and I'm going to paraphrase again, sorry if I get it wrong, but if I, myself and another parent, my child does something wrong to someone else's child, and the victim's parents don't think they have enough information about how the district handled it, what exactly are you going to allow us to tell that parent now? Because usually we say, well, we're not supposed to talk about someone else's child. If you want to call that dad or mom and ask them what happened to their child, you can do that. But I really can't tell you. But I was thinking, I don't know how deep you want to go, but if we look at the matrix that Laramie 1 had up there, you might say we found that this student violated this offense, and these are the range of consequences. They received one of those consequences. That's what you could tell them. An example might be, the consequence might be a 1 through a 10-day suspension. You could say they received a suspension. Now we don't even say that, but you wouldn't say how many days. So this is a very complex issue that you're working through for the person that has to actually do it. So let's say it all works and we all agree, but there's going to be some real issues at the district level implementing what you're asking superintendents to do in the future. And I'd stand for any comments.
Okay. Questions, comments from the committee? All right, thank you. Further public comment? Further public comment? Senator Rothfuss, did you want to divide the question?
Yes, thank you, Mr. Chairman. I just asked that it be divided into two different questions, 77 and 78, please. And I guess I would also ask, while on that, once divided, I don't quite know what the motion means, moving these along. Does that mean have them drafted as committee bills for our consideration at the next meeting?
Mr. Chairman,
Yes, go ahead.
that's what it means, and since they're already drafted, it means we'll see them next time in this form.
Right, Mr. Chairman, the difference though would be that right now these are Senator Ellis's bill drafts, and so that the idea by moving it along would be to have them drafted as joint education committee bills for consideration at the next meeting. Is that my understanding correctly?
Mr. Chairman, if I may inquire, Senator Ellis, does that meet with your approval?
Yes, Mr. Chairman, and just, this is why I requested this as an interim topic for us to look at, so that's why we're here.
Yes, go ahead.
Chairman, and then also with 77, there was discussion by both Senator Ellis as well with some of the witnesses that there would be some substantial work on it. And I assume that would then come in the form of an amendment or
Mr. Chairman?
amendments?
Mr. Chairman, I'd be happy to go in either direction. If it takes on a whole new life, it might be cleaner to have an alternative bill draft prepared. But if there are things that can be addressed more cleanly through amendments that aren't too complicated, that's another option. So
Okay.
some flexibility. I just don't know how we start figuring this out unless we start figuring it out.
Mr. Chairman,
Mr. Co-Chair.
and that's why we want to carry these bills forward as they stand right now, because then you can make a judgment as to whether or not you need an amendment, and we can get it drawn that will fit into this bill, or if you need a substitute bill, and then we could get that drawn.
So it keeps the topic alive, in other
Yep.
words. Okay.
And, Mr. Chairman, and gives us a vehicle that people can prepare amendments for.
Okay, you've heard the motion to divide the question.
That was just without objection.
Okay,
Usually
without
that's in order.
objection. And would you like to speak on behalf or against either side of that? Does anybody like to speak?
Mr. Chairman, just assuming that we're on 77 as the first division.
77, yes.
Yeah, again, I'm not averse to the overall concept, but this particular approach for legislation, I have real concerns about the appropriateness of us delving into the Public Records Act as a vehicle for us trying to find an enforcement mechanism to prevent bad behavior in schools. I think there are probably approaches out there that might be effective, and honestly, the alternative, which oddly enough, I probably wouldn't be that averse to, would be blanket legislation, but it just doesn't belong in this committee. If we were covering every public official in a uniform and equal manner, where if they had habitual bad behavior, heck, you might even get me to sign on to that sucker. I like the idea. It's just that this way, for one group in this committee, seems like it's not appropriate, so I'm gonna.
Okay, sensing you're ready to vote on division number 1, which is 77, all in favor signify by saying aye.
Mr. Chairman, if I could interrupt for just a moment as a point of order. I don't think that there was a second on Chairman Scott's motion, so if you could get a second, please.
Was there a second on second?
Thank you.
Seconded, okay. Are we all right? Okay. Yes. Okay, the first division would be 77, and the second division will be 78.
I would be to move
And,
77 forward.
Mr. Chairman, the motion is to carry it forward next time to consider as a committee bill.
Right.
And then next time we'll take up any amendments on it and follow the normal procedures for committee bill. So you're not committing yourself to the substance of it, you're committing yourself to have a serious discussion of the substance with the possibility of a bill coming forward, structured discussion with that possibility.
Okay, anyone else? All right, sensing you're ready to vote again, all in favor signify by saying aye. Aye. All opposed, no? No. Chair is in doubt. All in favor, raise your right hand. 1, 2, 3, 4, 5, 6, 7. All opposed? 1, 2, 3, 4, 5, 6. Motion passes. Okay, second division, 78. I guess that's been moved and all that, seconded, right? Are we just ready to vote on the second division? Okay, ready to vote on the second division, which is 78. All in favor signify by saying aye. Aye. All opposed, nay. Motion is carried. Okay. We're just past our break by an hour, but we made up some time. We are on item number 8, Board of Cooperative Education Services. It looks like Matt is in the hot seat. Go ahead, Matthew.
Thank you, Mr. Chairman, members of the committee. Again, Matt Wilmarth, Senior School Finance Analyst with the LSO. In your packet, you have meeting item number 8-01. This is an issue brief on Board of Cooperative Educational Services, and it's in relation to your priority number 4, which is the study of the funding, governance structure, and educational programs administered by BOCES, or Boards of Cooperative Educational Services. Just some background and history on BOCES. The legislature created the BOCES Act in 1969 to provide a methodology by where school districts and community colleges, or any combination thereof, may work together by entering into an agreement to provide educational services more effectively in a cooperative agreement. or cooperative effort. Currently, agreements to form a BOCES are approved by the State Board of Education. Initially, BOCES were not authorized to raise property tax revenue for their operations. However, in 1977, school districts comprising a BOCES were provided the ability to assess a board-approved mill levy not to exceed a half mil for the operating expenses of the BOCES. Then in 1989, the legislature further authorized the school districts of comprising any BOCES to levy an additional 2 mills for the purposes of providing post-secondary education services. The voter-approved mill levy is submitted by the BOCES to continue at each second general election following approval until the proposition is defeated. And then in addition to the voter-approved mill levy, in 1997, the legislature authorized a community college district's Board of Trustees to approve a mill levy not to exceed a half a mil every 2 years. The community college mill levy is limited to not exceed 2 mills when combined with any voter-approved mill levy. And I'll mention here, there are 3 policy recommendations for the committee to consider, and they all relate to mill levies, and they're a little bit nuanced. And so I'll touch on those as I go through this issue brief. But I wanted to kind of highlight that at the beginning, that I do have some policy recommendations on mill levies. Some of the language within the statutes is not clear, or perhaps there should be some further direction provided by the legislature. So with regards to BOCES, I categorize them into 3 separate sections. The first are post-secondary BOCES. The second are special education BOCES. And then the third category is K-12 or early childhood education BOCES. There are, according to the research available to me, a total of 21 BOCES that were operating as of last school year, the 21-22 school year. And of those 21, 16 related to the post-secondary BOCES, where there is a school district and a community college district that have an agreement together. There were 34 school districts that made up those post-secondary BOCES, along with 6 community college districts. For the special education BOCES, there were 3 special education BOCES, and 41 school districts participated in those BOCES. And then the K-12 and early childhood BOCES, there are a total of 14 school districts that participated amongst those. There are only 3 school districts and 1 community college district that do not participate in BOCES, and they are located in the southeast corner here of Wyoming. They include Albany County School District number 1, Laramie County School District number 1, and Laramie County School District number 2, and Laramie County Community College. I'll try to go quickly through my comments, as I know we're behind. Of the 45 school districts, there are 9 that did not assess any mill levies. 36 school districts had board-approved mill levies, and 4 school districts had voter-approved mill levies. Of the 6 community college districts, 5 had board-approved mill levies. My first policy recommendation or option that the committee may want to consider is the maximum number of mill levies school districts and community college districts can assess. And in discussions with both school districts and community college districts, it is not clear within the statute whether or not the board-approved half mil is for each agreement or in total of how many agreements that they are a part of. In my examples here, there is a couple school districts that assess 1.5 mil levies, and that is for 3 separate agreements. There are no community college districts that assess more than 1/2 mil. But there was a question to me, and I did not answer, but the question was, are we capped at 1/2 mil, or are we capped at 1/2 mil for each agreement. I think there's varying interpretations amongst school districts. So it may be worthwhile for the committee to clarify for both Wyoming Statute 2120-109 and 2120-110 on the board-approved mill levies, whether that 1/2 mil is for all agreements or for each agreement. Mr. Chairman, talking specifically about the post-secondary BOCES,
Maybe. Thank you, Mr. Chairman. Matt, so we've got the typical 3 flavors of BOCES. Is there really any limitation on what those could look like? I mean, it was my understanding that it was pretty broad in what could be covered. Those are the 3 that we see and that are implemented. But would it be out of the question for 3 districts or 5 districts or something to come together in cooperation in some other area that we haven't seen happen yet and create an additional district and maybe the 4th district for that? Or is it limited to these categories in some way that I'm not familiar with?
Mr. Chairman, in center office, I don't believe districts are limited in any way in which these agreements are, in which way they can provide these educational services. You're taking a little bit of steam out of my closing comments.
Why don't you
think,
just go ahead?
well, I'll kind of shorten it up here. I think there are likely efficiencies that could be utilized through human resources or transportation. I do think we see part of it through special education, but the special education really related to specialized services. There are recommendations from the Alvarez and Marcel that kind of focused on more of the HR or data system type of efficiencies. No districts utilize BOCES for those purposes. And they are really only focused on post-secondary for concurrent and dual enrollment purposes to pay for that coursework because students aren't charged. So districts, both community college districts and school districts, have to finance that in some manner. And so they utilize these BOCES revenues through the mill levies to pay for those. The special education BOCES, the 3 operate in almost entirely different ways. And there's, I'll let those representatives speak to how they operate their BOCES in a more detailed manner. But one BOCES does not provide any discount to their service members, and only one school district in the Northwest or the Northeast BOCES assesses a mill levy for the operation of that. No other BOCES assess a mill levy for that. The other 2 operate a little bit differently, where member districts do assess mill levies and help finance those. And then the early childhood education, I think this is maybe the only area where the Hot Springs early childhood BOCES, these districts from across the state have come together to, I think, do something similar to what you're trying to get after. But I look at it as they're assessing mill levies to offer something the state doesn't provide, early childhood programs. And so they're working with, their districts to coordinate early child efforts programs or educational programs amongst those districts, and they're financing it through a BOCES mill levy. But regarding to, being more efficient in your HR operations or finance operations or data systems, BOCES aren't being utilized in that manner.
Mr. Chairman, thanks. Just briefly, Fremont 14 and Fremont 21 have 4. The 3, I understand you've lined out 3. I get that, but so what's the 4th one that they do?
Mr. Chairman, Representative Summers, the 4th one they do is the Fremont BOCES. They are, the CWC BOCES, which is with Central Wyoming College. That is the BOCES that they do not assess a mill levy for. So they do assess a half mill levy for the Fremont BOCES. And then they both assess a half mil for their special education BOCES, both the Northwest BOCES and the Region 5 BOCES. And then their fourth BOCES is the post-secondary BOCES with Central Wyoming College. They do not assess, none of the Fremont school districts part of the CWC BOCES assess a mill levy.
Thank you.
Mr. Chairman, as I kind of alluded to, the post-secondary BOCES are really only for concurrent and dual enrollment programs. I won't get into the details. I've outlined each of those agreements within the issue brief. I'll just jump directly to my policy option here that the committee may want to consider clarifying the maximum community college board-approved mill levy. And this really only affects one school district currently, and it could be an interpretation. Western Wyoming Community College assesses a 0.331 mill levy. Uinta County School District Number 1 has a voter-approved mill levy of 2 mills. When you look at that in isolation, that 2.331 mills exceeds the statutory cap of 2 mills when combined with the voter-approved mill levies. I'm not sure if the 0.331 mill levy is with the Uinta BOCES in Uinta County School District Number 1, because Western Wyoming Community College has 8 BOCES agreements. And so the policy option could be just eliminate the cap that, hey, the board-approved mill levy for community colleges could just be 1/2 mil and don't combine it with any other school district mill levy, voter-approved mill levy. But I think there could be an argument that the 0.331 mill levy, when combined with the 2 voter-approved mill levies in Uinta 1, exceeds the statutory maximum of 2 mills. And so you may want to clear that up, either just what you do with the board-approved mill levies for school districts, just don't cap it at 2, just say a community college district can assess a 1/2 mil, but it still gets to my first policy option. You may want to clarify, is that 1/2 mil for each agreement or in total? Finally, related to post-secondary education, I've brought in a discussion about the adult education program mill levy. And this precedes the creation of the BOCES Act. And in 1945, the legislature initially established the ability for school districts to maintain an adult education programs. And I actually believe this was before community college districts were created by the legislature. And currently there are 2 school districts that authorize or have voted in, or their electorate have voted in adult education program mill levies. Those occur in Carbon County School District Number 1. Their voters have approved 1.5 mill levies, and they actually transfer those revenues to the BOCES to support the BOCES. The other is in Fremont County School District Number 1, where they have authorized up to 2 mills in 2006 to be authorized for the purposes of adult education programs. The policy option here is the current language in the law indicates that or that these adult education program mill levies are governed by laws governing school elections. And I think this is archaic language when mill levies were assessed beyond the current structure for K-12 education. There is no direction in the law when to reauthorize this mill levy. And so in talking with the clerks in both in Carbon County and Fremont County, they have not gone back to the electors of those school districts to reauthorize those adult education program mill levies. So the one in Carbon County School District was authorized in 2000, in the 2000 general election. And in Fremont County School District Number 1, it was in 2006. So the recommendation here, essentially these mill levies are now in perpetuity. They were put on in in one case 22 years ago, and in one other case close to 16 years ago. So policy option would be, and this is in contrast to what we've done with the BOCES mill levy, where they have to go out and vote on at each second general election. So the short of it is perhaps a policy option would be to clarify when these adult education program mill levies are reauthorized. Is it, you could do every 4 years, 20 years, whatever. Just provide the county clerk some direction.
Mr. Chairman?
We've got Mr. Co-Chair first. I can't get my mic to work.
Mr. Chairman, in addition to the mill levy problems that Mr. Wilmarth has brought to us, that I think probably sooner or later going to have to deal with, the 3 BOCES that deal with you call them special education, but they sound to me like they're really dealing with the troubled youth, as I understand what they are. And Mr. Chairman, well, first a question for Mr. Wilmarth. Am I right in thinking that these 3 BOCES are running residential treatment centers that do deal with these students with significant behavioral problems that need that kind of treatment? Is that a correct understanding?
Mr. Chairman, Senator Scott, yes, but that's, part of the services they provide. I think they would, and I think Mr. Mayor will follow my comments. I think they provide the full spectrum. There are probably some school districts who can't offer some services, and so they do refer them to a BOCES to provide those services. But I will defer maybe more details on those types of services to Mr. Mayor after my presentation.
Yeah.
Mr. Chairman, I want to come back to that after we've heard from him.
Sure.
Because this meshes with what I was starting to see in Committee 10, where we were losing the institutions that provided these services. And this is enlightening as to why we were starting to lose them, Mr. Chairman.
Sure.
So let's hold that open.
Okay, I saw someone down here with their hand up. Yes, Kathy.
Thank you, Mr. Chairman. Mr. Wilmarth, this was actually a fascinating memo. But I'm curious, you set out 3 different policy choices for us, or examples, where the statute could be interpreted in at least 2 different ways. And do we want to change it? So my question to you is, do you know if there has been that ambiguity, that a district has read the statute and has decided, no, in fact, we can't issue a new mill levy? Or, so are we having a problem is the question before that I'm curious about.
Go ahead.
Mr. Chairman, Representative Conley, I was asked by a community college district if they could assess additional mill levies for multiple half mill levies for multiple agreements that they have. I said, I'm not your attorney, I can't interpret that for you. So from the community college perspective, while there are no community colleges that are assessing more than 1/2 mill, the question was asked. In school districts, there were a few conversations, and I think you can see from the data, there are some school districts that have multiple agreements and their cap is at 0.5. There are multiple school districts where their cap exceeds the 1/2 mill and they have multiple, and I think Representative Summers brought up the Fremont County School District from 14 and 21, where they have 3 agreements where they assess a 1/2 mill for each agreement. There are varying interpretations. And so I just wanted to bring it to the attention of the committee and the legislature that there are varying interpretations amongst the conversations I had with both school districts and community college districts.
Okay, other questions for Matt? Yes.
Thank you, Mr. Chairman. Mr. Wilmarth, excuse me. Can charter schools be part of a BOCES? I didn't see that anywhere in there, and they're kind of in between, right? They're part of a school district, but not. So where would they fit into the BOCES discussion?
Go ahead.
Mr. Chairman and Senator Beitman, good question. The statute only contemplates school districts and community college districts. It does not bring in specific charter school districts or charter schools. I mean, while they have a separate board, they have no authority to assess revenues or mill levies. And so I think the answer there is they would benefit as part of being the school district that is a part of an agreement. So if a charter school student partakes in dual and concurrent enrollment courses through a post-secondary education agreement, that is one way they're part of that BOCES agreement, or through some special education BOCES agreement that the district is a part of. But I don't believe they can directly partake in an agreement because they are not authorized.
Okay, other questions for Matt? All right.
Mr. Chairman, I'll make my comments brief on the special education BOCES because we have the experts in the audience. As I indicated, there are 3 special education BOCES. They do provide an array of services, not just special education, and I think they'll speak to this. It is not just special education services that they provide, but they also provide professional development, cooperative purchasing agreements. And so the 3 are the Northeastern Wyoming BOCES, which is located in Gillette. The second is the Northwest Wyoming BOCES in Thermopolis, and the third is the Region 5 BOCES in Wilson. As I indicated, they provide an array of special education BOCES or services. The one up in the Northeast Wyoming area has 13 school districts, but I indicated only one school district, Converse County School District number 1, assesses mill levies to support that BOCES. They utilize that mill levy for their operations, and they also provide additional services to the school district to provide students educational programming across the full spectrum in K through 12. That BOCES also offers cooperative purchasing arrangements for school districts throughout the state. And they also have a day school program located in Sheridan. The Northwest BOCES is located in Thermopolis, and they focus on K-8 grades and with students with emotional disabilities or behavioral disorders. They have 18 school districts that comprise their BOCES, and not all of those 18 assess mill levies, but majority do. And then the Region 5 BOCES located in Wilson, they have 7 campuses located across Wyoming that serve students, and they also provide professional development, and then they're also implementing the SAFE Student Alliance project on behalf of the Wyoming Department of Education, which was a 3-year grant awarded to the state from the Department of Justice. And they have 13 school districts that comprise that BOCES. Finally, Mr. Chairman, I kind of talked about the early childhood BOCES, but I'll just summarize that again. That is the Hot Springs Early Childhood BOCES. It's comprised of 7 school districts across the state. 5 of the 7 districts assess the half mil, and then 2 others assess less than 1/2 mil. And then the final BOCES is more of a traditional K-12 BOCES, which is the Fremont County BOCES. And this BOCES provides educational services to the Fremont County school districts, except Fremont County School District number 38. And they partnership with industry, adult education, special education, and preschool education. Mr. Chairman, to kind of summarize my research, I looked at 3 studies that have been done in the past regarding BOCES. The first is related to the special education BOCES in 2017. They commissioned a study to look at those BOCES and their financing, and really a way to kind of move them forward. I think Chairman Scott alluded to, that they were struggling financially and they were looking for a pathway to look at alternative funding considerations. So that study focused on that piece of the BOCES. As part of that, last year, 2022, House Bill 50, BOCES' local education agencies was brought forward as part of that working group. And that's included as Appendix 3 in your meeting material to this issue brief. And I think Mr. Mayor will discuss that later this afternoon. The second study, as I indicated, was from the Wyoming Governmental Spending and Efficiency Commission. This was Alvarez and Marcel. This really focused on the more the programming that isn't really related to educational services, but rather, how to develop or create regional shared services for human resources or financing or information technology or other services that can be provided more efficiently across school districts rather than by each individual school district. I've included that as an appendix as well. Related to those recommendations from the Alvarez and Marcel, the first and third recommendations related to kind of the human resource or IT or finance piece, and then the third, which is the third recommendation from them was related to parents being made aware of the opportunity to invite the Department of Education to participate in disciplinary team to help with awareness of federal funding alternatives and coordination across parties and with BOCES. Those two really have not been acted upon by the legislature. But the second one, which related to collaborative purchasing by BOCES, was acted on by the legislature. There was a footnote put on the budget bill to the Department of Enterprise Technology Services on doing cooperative purchasing for school districts on computers and software. ETS recommended no action by the legislature on that. So the legislature has acted on that recommendation. And then the third study that I reviewed as part of this work was a 2021 report completed by the Region 11 Comprehensive Center at McCrell International. And this was in response to the 2017 A&M study related to the shared services model recommendation. And it, again, really focused on the fiscal and operational practices of BOCES in school districts. And the legislature obviously has not taken up that report or the recommendations contained there, and I outlined those. So with that, Mr. Chairman, that is a brief summary of the issue brief, and I would be happy to entertain further questions.
Yes. Robert, go ahead.
Mr. Chairman, thank you. And, obviously the last study, I guess, or the last, I don't know if it was a study, but anyway, the last group that was put together, task force, I believe it was a WDE task force that McCrell headed, and I was a part of that task force. And so, a task force was created, recommendations were made, and it didn't even appear we were going to take and hear what those recommendations might be. So that was one reason I wanted to see this on our agenda, is they went to a lot of trouble. They made a lot of meetings to try to figure out, are there ways to find, to find savings with, basically, can you do shared services and get savings out of it? And what are some recommendations? And so I thought it was important that the legislature at least hear that, right? Instead of it just being buried in the bottom of a report. And then ultimately the bill I brought was more about finding a way for BOCES to be eligible for really federal dollars. And I sat on that bill basically just to let it come before this group and see if we have any consensus on what we might want to do.
Is that your review of House Bill 50?
Yeah, that was basically my review of House Bill.
Okay,
50.
is that on the agenda? All right, any other questions? All right, Matt, thank you. And if that was your review, we're ready for Region 5, I believe. Welcome. Please identify yourselves, introduce yourselves.
Thank you. Chairman, members of the Education Committee, my name is Dan Mayer. I'm the Executive Director for Region 5 BOCES. I have with me today Ted Hansen, Region 5 BOCES Outreach Director, and Taylor Jones, Northeast Wyoming BOCES Executive Director. Carolyn Connor, Northwest Wyoming BOCES Executive Director, could not make it. I know she's listening in, and Samantha Hannon, our business manager, is participating virtually with us, so if there's any financial questions that you may have, she can answer. We did create a small presentation, and we provided a lot of information regarding, one of the asks from the LSO was what other states are doing. And so we provided some comprehensive information to you, and I have some summary information. There's a lot there, and I have some brief summary, but I wanted to provide that. For the sake of time, we can go through our presentation for you. We can jump into questions. How would you like us to
If you
proceed?
could give us a brief
Perfect, we can do
summary
that.
to start with, and then I'm sure that'll
All
lead
right.
to some questions.
All right. Is there a chance we can pull up that and just slide through that? Thank you. I'll start. The slide I'll start with is our hope today. We want to recognize that BOCES are an integral part of the comprehensive education system in Wyoming. Our other hope is you walk away understanding programming costs and funding sources available to BOCES to provide services. Understand how other states fund their BOCES. Keep in mind, they're also known as educational service agencies. So when you look across the country, BOCES, they're called many things in different states. I just found out, I believe, that there's 3 states that actually call their educational service agencies BOCES. That's Wyoming, Colorado, and New York. Consider a statutory change that would allow BOCES to be designated as a local education authority for the purpose of applying for state and federal grants. Oh, go ahead.
So, Mr. Chair and committee members, Ted Hansen, Outreach Director for Region 5 BOCES. And as discussed by Senator Scott, we do serve students with disabilities primarily at our residential program in Wilson and at our day school programs for the region that we serve in Southwest Wyoming. We have 5 day school programming. The purpose of day school programming is to have students stay in their local community. They attend school at one of our campuses, and then they return home at night. And of course, a residential facility, the students are under 24-hour care. It was interesting to me earlier today with Laramie 1's presentation and the spike from 7th grade to 10th grade. Really, that's where we see the spike in our services as well. 12-year-olds to 17-year-olds. Northwest BOCES serves the younger population for the state primarily. We all have the ability to serve the younger population, but Northwest focuses on them. So as alluded with the BOCES bill, the importance is to provide effective programming for students with disabilities. IDEA requires that, and these are public education students in Wyoming. So under the IDEA, there is a requirement that a full continuum of services be provided, from general classroom support all the way to restrictive settings that include residential facilities, home hospital, detention centers, et cetera. IDEA requires that every school district have the ability to afford students that placement. The residential BOCES in Wyoming is the mechanism to allow Wyoming to meet that requirement. There is no other mechanism in Wyoming for that to take place. Senator Scott earlier alluded to the Boys and Girls School, and as indicated, that's through court system, so that would not meet the requirements under the IDEA. So the BOCES are how school districts in Wyoming have a mechanism to support students publicly to meet the requirement of IDEA. And as indicated, there are districts that our member districts and districts that are not, in a variety of situations across the state where mills are an opportunity to support funding and/or fee for service is the other, and we'll go into that a little bit more. But the importance of the BOCES is to ensure that we have effective service. It would be very inefficient and ineffective for a school district to try to offer a continuum to residential placement because of the staffing requirements, because of the specialty, because of the training requirements, et cetera. So that is the function that the BOCES provides, the specialized training, the specialized staff, and the ability to provide the 24-hour care. As indicated, we serve students with fairly significant behavioral needs, typically physical assaults, physical intervention between student to student, student to staff. And again, our staff across all the BOCES are trained to support that type of behavior. However, that comes with some additional concerns that we'll also address here in just a few moments. One of the other considerations is that we are also a recipient of DFS placements. So a student may be placed with us through the DFS system, and that does not come with the same level of support and funding as a school district placement. And again, we can go into more detail if there are questions about that. The data we have is that 77% of districts in Wyoming have used one of the 3 residential placements from 2014 to 2016, and that was pre-COVID and the last data that we have available. So 77% of districts have used a placement across Wyoming. And in the last decade, the data that we have is that 92% have utilized a placement at a BOCES facility. 40% of districts support the special education, or what we're calling our BOCES, the residential BOCES, through a mill levy. You're keenly aware, I know, of the constitutional requirements to provide equitable education for all students across Wyoming. And so again, just ensuring that the equitable opportunity exists for all students and what the funding mechanism could be to support BOCES in thinking about that in a different manner. So I am on, I'm sorry, slide 6 now, and just this is a re-highlight of the continuum of educational placements, just to give the legislators a visual of where the BOCES fall on the continuum. So you can see on the far left is the general education placement. Then it's general classroom for part of the day with some special education support and services within a school campus. Then there may be school districts that have self-contained settings or district programs where students are in a special education setting for most of the day. Those 3 placements, most school districts in Wyoming can figure that type of placement out for a student with disabilities. And then when you look across the continuum from there, we begin to get more restrictive to the day school option, which is the option I described, where a student would come to one of our campuses for part of the day. Some school districts have day school options, typically larger, or school districts that have that level of need. Smaller districts, 1 student, it becomes, again, not feasible to have that type of placement. And then residential facility, that's where all 3 BOCES support that placement option for the continuum. Hospital or institution, homebound instruction and detention facility, again, we are not involved in those placements. And the next slide, please. Yep.
So I have a question. I think I know the answer, but there are other residential treatment facilities outside of the state of Wyoming, right? So there are districts that go outside of the state of Wyoming, outside of these BOCES to get those. So those kids are going somewhere else, right?
Yes.
Do we have any idea what percentage of kids are I mean, you said 90% over the course of time, but let's just pick the last year, which is, I know it's a weird year, but you have any idea what percentage are in your are in one of these three facilities, one of the three residential BOCES versus out-of-state residential treatment centers?
I'm not sure if I have that information, like how many students are. I know that this topic was discussed. There was some information that was presented to the Labor, Health, and Social Services Committee that I attended a few weeks ago, that were talking about those numbers, and they had a better breakdown of those numbers, but I think I can get that information and get that sent to you. In regards to how many districts, in comparison, I think there's a, I think I don't have that information right now, but I can get that information to you.
Okay. All right, proceed.
Slide 7, please. This is just one more visual to show the continuum of services. And so on the left, you will see the little orange dot in the target, and that's general education. So again, that's the statutory requirement for all students in Wyoming, is that they receive the basket of goods. The next layer is when you become eligible for special education by being identified as having one of the 13 disabilities, you get a selection of services that are identified on the individualized education program that includes special education, and that could supplement the general education or support the general education. And then in addition to that, there are related services, speech language services, occupational services, physical therapy, et cetera, counseling, social work, on down the line. There's a whole gamut of related services that would support as well in special education. So at a BOCES, all three of those requirements are met: general education, special education, and special education and related services. That encapsulates FAPE, which is free appropriate public education under the IDEA, meaning that all of those services are free to families for students with disabilities through public funds. And in order to receive that, you have to go through the process there on the right. You have to be evaluated for services. So there's an evaluation that takes place that makes them eligible under Wyoming statute under one of 13 disabilities. Determine that there is a need for those services, develop goals based on those needs, develop services to support those goals, and then determine, after those services are implemented, the educational benefit. That encapsulates FAPE. I think that's good.
All right. I'm going to go into costs for serving students in residential facilities and day schools. This is something that I've discussed just as a reminder. We occur all the costs, the service costs, operational costs. An additional cost that we've all discussed is our workers' comp costs. It's in the tune of about upwards of $1 million paid out to current and former staff amongst our organization because of the nature and severity of the disabilities. We are often in restraints and things like that, and there's injuries to people. So that's a cost that's hidden that we need to, it's hard to have. Our funding source currently, the block grant components not captured in BOCES fee structure, cost of living adjustments, professional development, rolling average, regional cost adjustments, small school funding. Essentially, how we make up our costs is we receive mill funds from the districts who participate, and we charge fees. We are part of the National School Lunch Foundation. That is one grant we do qualify for. I believe it's because our students are considered homeless. And so when you think about capital construction, maintenance, and utilities, Title I PERK and 6Bs and all those other costs that come in, those costs do not come our way. So the last slide is our ask. We wanted to be specific because today what we really want to focus on, this is a big puzzle. I think there's a lot of pieces to this when you're talking mill levy. I read through Mr. Wilmarth's presentation. There's a lot of layers to this onion. But today what we're asking is for this body to consider House Bill 50 in identifying BOCES as an LA for the purpose of applying for eligible state and federal grants. It'll help us support programs designed for students with high needs, those we serve on behalf of districts and state agencies. Expand services that we can offer currently. I heard some of that conversation happening. Could that provide opportunity for it to even expand some of the services that we are offering? Keeping students with special residential needs in Wyoming, and eventually their communities. I think that's one thing that all of the BOCES have done in the last several years is create a lot of options in the local, or trying to create those local, so we're not sending students out of the communities and trying to serve them in their local communities through our day programming. We've really tried to focus in on supporting special ed services, particularly in more rural communities where it's hard to find those providers, or the need for the provider is so limited that you cannot find one FTE, you may need a partial of an FTE. And, you know, near and dear to Region 5 BOCES, help funding for facilities. As we're talking about safety and the latest and greatest techniques to keep kids safe, active supervision and those things, it's hard for us with those rising costs to keep up on some of those facilities. I know, at least for us, that is. You go to the next slide, I want to jump into what other states are doing. Yep.
Yes, go ahead.
So, Mr. Chairman, when I wrote the bill last year, I put in state as well as federal, but is there really a need for state grants? Because really what you were targeting was federal grants. And I think the one thing you didn't mention also is, in the bill at least, it required the approval of at least 2 districts before you, you know, so you're not going to do anything that's competitive with districts. You're just seeking grants that may not be available otherwise.
Yep.
Pretty much federal grants.
Yep, federal grants or other, I would hate to limit us, you know, I think with the, I guess I don't want to answer that too hastily if I'm not certain, but I think if there were state funding that could come in that I'm not aware of, that would come in a grant type of, you know, I would want to make sure all available money that could come our way would be able to come our way in that way. But it is more of a target on those federal dollars. That's where the notion came from. We just modeled it after the Colorado BOCES bill that they did in 2011 to extend that. They provide a lot more comprehensive services than what we currently do. And they just found what they saw in the state as a gap when some of these, theirs was ARA back in the days when the ARA funds came in. They weren't able to, those entities weren't able to access that, and this was a way for them to do that with participating districts. And that this issue became again because of the CARES funding, became an issue again. So yes, that is accurate. In other states, I provided a spreadsheet, so I provided a lot of information. It says the same thing, it's just represented in multiple ways. And we turned it into an Excel spreadsheet where you could filter through the information a little bit more readily to find out what that was. But is there a definition for LEA status, and how many states do you actually define it? 26 of the 50 states actually define what an LEA is. So there's 24 states that don't even define that. Furthermore, are LEAs, or excuse me, educational service agencies or BOCES included in that definition? Of those, 9 of them include a further definition. And then when you take that all out, are there other funding opportunities that are available regardless of this LEA conversation? You have 28 of 50 that say yes, there are. And if you look into further detail, a lot of times it's around special education, post-secondary, the same things that we're talking about. So it's not unfamiliar for other states to provide that. But it looks different. When you look through that, there's no common. Each state operates it differently. They define it differently. They offer resources to that. And just working with a multitude of states, this was something that would provide another revenue stream for our programs that seem to match some of the programming that we offer moving forward. Let me see here. I have a lot on that. Go ahead, Taylor.
Mr. Chairman, members of the committee, thank you. I think one of the reasons we're here today is to kind of ask the question, how does BOCES remain relevant? And we do have, as I see it, a lot of gaps, especially in the opportunities for funding that would help us fill those gaps. I don't want to be redundant here, but we do work with some of the most challenging kids in the state of Wyoming. And the best way to offer them the best service is through relevant and meaningful and evidence-based and research-based practices, all of which obviously cost money. I think more important than that is recruiting and retaining really quality and qualified candidates. And so I think that kind of causes some disparity in what we can offer in terms of salaries and things like that. You know, when you talk about the most challenging kids in the state, not a lot of your quality and qualified candidates are knocking on the door at some of the rates that we can offer them. And then we also consider what it costs for building and maintenance. Right, we're generating the funds through our fee-for-service model. It sometimes makes it difficult to keep up on the maintenance.
I believe we had some additional materials that were sent to you. We had a few letters of support from a couple of the BOCES. We've met with several of those individuals and just some general talking points regarding the bill specifically and some examples of the funding that were provided. At this point, we can stand for any questions about the bill, our services, any other questions that you may have. And we presented on the bill, but we're ready to answer any questions you may have on any other topic.
Mr. Co-Chair.
Mr. Chairman, a couple of questions as I'm trying to grapple with this. One is, to what extent, when you look across what you're doing, what some of the family services agencies are doing, to what extent are we sending kids out of state, and are we having difficulty placing those, and are they a lot more expensive than handling them in state? And the second question is, what's the difference between a child that comes to you through the school system and one that comes to you through family services? Why do the children go one way or the other?
Go ahead.
Chairman, Senator Scott, your first question. What we're finding is that some of the students' behavior are becoming pretty significant, where it's becoming more difficult to serve them in facilities. So their special ed needs, their intellectual level, the severity of their behaviors make it awfully challenging. There's very few, and it's mostly our entities that serve that population. We hear anecdotally that even some of the psychiatric residential treatment facilities may not even take those students if their disabilities and those needs are so severe. So we don't have a lot of those other agencies that work through don't handle those severe IEP challenges. So when we're not able to meet those needs because of, and recently it's been a challenge because of staffing, we're facing the same challenges as our school districts, being able to pay a competitive wage, keeping up with all of that, and taking a very difficult population and serving them. I hear again anecdotally, I don't place those kids out of state, but I know that they are expensive. We hear how expensive we are. I mean, I would happily sit down with anybody and share our finances and why we come up with that and why it costs that much. I do know when they go out of state, I do hear, again, anecdotally, it's much more expensive. So I do think figuring out how to serve these, well, number one, it's just the right thing to do, is to serve our kids closest to the home that they have. And when we have to send, even when we have a kid from Torrington who's coming to our facility in Wilson, that's still a significant, change for those kids. And then when you think out of state for the parents and, trying to bring kids back. So it is more of a cost. If we could figure out a way in our system of care in our state to serve these kids, I think it would be I think we'd be more able to serve these kids, and I think it could bring in some efficiencies in that manner. Your second question about the cost, I think, or the difference to that, how do kids come to us through the court system? We're an entity that sits in the middle. So we didn't always take court-ordered kids. So when we first were enacted, we provide regional services for handicapped kids. I believe it's still, so I'm using the correct language, but I know we've changed that language. And we provided that because districts weren't able to. And this is when Public Law 94-142 was first enacted. That's the IDEA law. And so as districts' capacity to be able to serve those more difficult kids, we changed along with them. And somewhere in the late 90s, I've gone back and looked, we started taking court-ordered kids because I think the court system and districts saw that kids were getting into legal trouble, but it wasn't because they were criminal. It was because of their disabilities, their intelligence levels, their behaviors. So they worked on an arrangement, I wasn't there at the time, where we could take court-ordered kids as an educational placement. So in talking with Director Schmidt from DFS, we're not a first line of placement for her. There's other placements that they look at, but when the educational need outweighs those other things, that's when they come to the BOCES programs. So that's how we get DFS kids. Districts, we still serve in that way. When they are, as an IEP team, as our slide indicated, that IEP team says we cannot meet the student's needs in the school anymore, the IEP team will make that decision and we will place that student either in one of our day programs now or potentially in a residential program. And we work closely with that district to work with that student to get that student to come back into that environment. The cost difference is that we can set the rate with our districts because we work with them. We set the fees, the mill levy. With the court-ordered kids, that's set by statute. You set the rates for the cost for some of those DFS side of that as a legislative body in labor and health. So we're caught in this, we serve them, but we're really an educational facility, if that makes sense. So we're the last step before they place kids out of state. They come to us, and then if we're not able, a lot of times they have to look out of state for that. Does that answer your question?
We'll follow up.
Yeah, Mr. Chairman, we're dealing here, I think, with a major mess in our state government. We're dealing with kids that are very hard to deal with, that if you tried to deal with them in the strictly school setting, they would be enormously difficult, and we're just not equipped for it and be very disruptive. I think there's a good deal of similarity between the population that these BOCES are dealing with and that are dealt with through the DFS court-ordered placement thing. I'm not sure there's clear delineation as to which is which, and I strongly suspect that some of the relevant bureaucracies are trying to shed their burden onto somebody else, with the consequence that we're having financial viability troubles right across the spectrum here and with our residential providers, of whom we've lost a significant number. I know the residential psychiatric treatment at the psychiatric hospital in my town quit half of its adolescent units because they were not profitable. Simply because we weren't paying enough to be competitive, and they were for profit. And they said that with you. So we've got, Mr. Chairman, a major problem. It sounds like Committee 10 is working currently in the same area. Mr. Chairman, I don't think that this committee alone can solve this. I think we're going to need to work with Committee 10. I think we're going to take a hard look at what this is doing to our education system. And one way or another, Mr. Chairman, I think the state's going to have to spend some more money in this area. And what we should do about it is unclear to me, but I don't think we need to make sure that the ball isn't dropped on this one.
Before I call on you, you alluded a little bit ago to a staffing issue that affected capacity, but do you also have a space limitation there, or how are we doing as far as having enough facilities? Or what are the limiting factors to you being able to take more kids?
Staffing right now, I think maintaining a well-trained staff. Not only do we provide the education, we have all the basket of goods, the special ed, as Mr. Hansen discussed. We also have to make sure that our facilities are DFS certified, which is a whole nother, so there's background checks and a lot of things. For us to process a new employee, it'll take a couple weeks. We can't even start people. It's like we have a desperate need. They can't start until they go through several things, and we're trying to expedite those processes. So there's a lot more that goes into that. I think the nature of our students, it takes a special, and there are people who choose to do that, but they're very, so it takes a lot of training and a lot of, to keep people safe. I think that's some of the, I would say we have some pretty loud exits that people see, and we have many more successes, but sometimes those loud exits harm people, and it really can be traumatizing for the staff that we have and working with the traumatized individuals that we have. So I would say that facility-wise, I think it's just funding to make sure that our facilities are safe, updated, with all the, like I said, there's so many things that they're doing with supervision, and that you see newer facilities, and it'd be nice to be able to update that so we can have a more, our facilities were not built, my facility was not built back in the day to serve the population that we're necessarily serving. It was a different population. And as that changed, I don't think we kept up with those changes as much as we could have. And just the financial changes for that. I think those are the two big for us.
And Mr. Chair and committee, I would just add that I believe across all of the BOCES this year, with the exception of maybe Northwest BOCES, Carolyn's not here to speak, but we have hit capacity for the number of staff we have. Not being able to hire qualified individuals to come into the organization has prevented us from taking referrals. So there have been referrals that we've had to say no to because we are not fully staffed. If we are fully staffed, we can take more students.
We're licensed for 45 beds. I think we're currently operating like 2025, significantly down.
Would you say that that's a factor in forcing some districts to look out of state for?
Absolutely. If we're not taking those students, I don't know many other facilities that will in state.
That's what I thought. Okay. Representative Summers.
Maybe. Mr. Chairman, thank you. And I agree. I mean, I've been watching this my whole 10 years, ever since the first time I took a tour of C-Bar-B in Jackson. It was clear to me that not only was it a challenging population, but the facility itself, you know, was kind of being run on a shoestring. And yet it's something every, you know, districts at different times have to have those. Do we want to ship them all out of state? I don't think we do. I mean, I'm curious, one is, you know, how large are those out-of-state facilities? You know, they're in Salt Lake, I know in our area. If you want to go somewhere else, you go to Salt Lake. So I don't know how large they are, but is that the way we want to serve Wyoming kids, by sending them out of state? Even if it's a challenging population? I don't think it is. You know, the bill before you is simply, and when the time's right, I'll make a motion to draft it as a committee bill, is just simply to allow these folks to access some federal dollars if they were to come into existence. The state piece, I would take it out, because I don't think that's necessarily pertinent. But I think what the good co-chair said in relationship to Committee 10 is right. This is a large problem. This has been underfunded. If it was, if there was a for-profit model in Wyoming, it would be in Wyoming. It doesn't exist. And it exists in other states because they have tremendous populations, and they're able to have larger facilities, is my guess. But I do agree that we need, this has needed looked at for a long time. And the funding, you know, you'll see a discrepancy in the mills. Some districts won't even provide a mill because they don't want to make that decision as a board, right? Because when you make that decision as a board, you're taxing your local people. Some are willing to do that. And I think they make that, is that every, and maybe I'm looking at Janine, do you do that decision every year, every 2 years?
Every year.
It's every year that that board has to make the decision to tax its people.
Yep.
Whatever mill levy they want to tax. And so, you know, that's why you see sublets small. We have a lot of valuation. So our small mill is, you know, is equal to a larger chunk. But it's really all over the board. And then some schools just want to pay based on a student. They're just going to bet we're not going to have one of these we're a small district. We're only going to have one of these the odds are once every 7 years. And then we're going to eat the cost when it comes. And I guess I wanted to agree with the good co-chair that more needs to be done looking at this in the long run to make it equitable for these kids, you know, and districts. And, you know, just because it's a challenging population doesn't mean that we don't want to have that challenge in Wyoming, because I think it's absolutely important that we do. But like I said, the bill is a fairly simple bill just to try to access federal dollars if they come available. So thank you, Mr. Chair.
Mr. Chairman, before we continue, I just wanted to let you know that Director Schmidt is available online if you did want to hear from her.
Okay.
She may be able to answer some of the questions you had, Senator Scott.
Yep. Looks like she's on. Welcome. Can you hear us?
Yes, Mr. Chairman, thank you. Mr. Chairman, Mr. Co-Chairman, members of the committee, my name is Corin Schmidt. I'm the Director of the Wyoming Department of Family Services. And there were some interesting questions posed about the intersection between the Department of Family Services use of BOCES versus a school district use of BOCES. First and foremost, the residential BOCES, the RBOCES, I think is what they were referred to earlier, are an important component of the provider system that we use. So in regard to a DFS child, the way that a child would be placed at a residential BOCES would be through an initial court action. So in order for a child to be placed through DFS, the court first makes a determination if the child is abused or neglected, if the child is in need of supervision, or if the child is a delinquent. If the court determines, the juvenile court determines one of those three things is true, then the court places the child into our custody for placement for in this case would be educational treatment. When we have a child with identified educational needs, we will often go to a BOCES to see, and if the child needs some sort of high-level residential treatment, we will inquire the BOCES to see if the child is, one, appropriate for their program, and two, if they have space to accommodate. One of the questions was, and this is specific to children in state custody, how many of the children are being served out of state? So children in state custody being served out of state in a residential treatment center is about 11 at any given time. That does not include children who are placed in psychiatric residential treatment facilities, which are a very high level, hospital level of care for children with high psychiatric needs. So the level of care that BOCES provides, and also our residential treatment centers throughout the states, are not necessarily psychiatric in terms of needing a psychiatrist, but really a combination of mental health needs, educational needs, and behavioral needs. There was some reference made to the need that we are seeing, and I think it was Mr. Co-Chairman Scott that made the reference. We are seeing a lot of children with multiple needs coming into our care. And these children need educational services. They oftentimes have lower IQs. They may be developmentally disabled or intellectually disabled, and then also with co-occurring mental health issues. So these are a very complicated set of kids. At any given time, we have about 15 that we're managing through combined case management with the Department of Education and with the Department of Health. But we are at a place where treating these kids in state is very difficult for many of the reasons that Mr. Mayor pointed out. Staffing is difficult, and oftentimes the behaviors are extreme. And in some cases, the educational needs are severe when we're looking at some youth with severe autistic needs. So just to hit on a few of the questions that were asked, and I can stand for any questions if you wanted to dig any deeper.
Any questions from the committee?
Mr. Chairman.
Yes, go ahead.
So Corin, this is Representative Summers. So obviously, you know, from what I hear from you, that it kind of takes a village, right? I mean, it takes what we have in Wyoming and what we have out of state, but we certainly don't want to lose what we have in Wyoming. Is that accurate?
Mr. Chairman, Representative Summers, that's completely accurate. And in all honesty, I've always been very confused by the whole BOCES funding, because the way that the Department of Family Services pays for services is through the court-ordered placement statutes. And with a state custody placement at a BOCES, the Department of Education, the Department of Health, and the Department of Family share the costs to serve those kids. However, in Wyoming, what we know is that access is an issue. So while we're paying a daily rate, it also depends that there's going to be a certain number of children there to cover the basic operational costs of that facility. So when thinking about a BOCES, which does provide a unique educational aspect of treatment, certainly I can understand the difficulty that the BOCES are having in being able to continue to provide those services, but also the complicated nature of how they're funded.
Any further questions?
Chairman, if I may.
Yes, go ahead.
Representative Summers, during the suspension and expulsion conversation, you asked a question, what are we not doing? And I waited for my public comment when I was up here because I think it's related. One thing in my preparation in doing this is that I've noticed in other states that they have a funding that's not tied to any hoop or, you know, disability category or any, like a high needs slush fund of funds that can serve these kids. Because one option people didn't say, because I don't think anybody's represented there, but some of our day schools have served some suspended, expelled, non-IEP students to give districts that option. The barrier to that, why we don't do that more, is funding. Special ed students come with 100% reimbursement in our state. They're well funded. We can serve those needs very well. When we have students who are not maybe eligible yet, or for whatever reason, that's more limited because it does cost to be able to provide that extra care. It's costly because there's a lot of human capital that goes into that. So I think that would be I think that's an option that we've used some of these other facilities, and I hear that happening more and more to diversify the population that we're taking. To maybe even start picking up some of those other students. But that's been a barrier. We've been willing to work with our districts when they've brought those cases, and we've figured out creative ways. But it's often led me to wonder if there wouldn't be more students that we could help districts with to get them to help. Maybe their school's not the appropriate place right now, but we can keep a safe place, make sure their education's in, it's not online. For some students, online is not maybe the best option. We can keep eyes on those kids and make sure they're supervised and keep everyone safe and they're not disruptive in the schools. So that's something I wanted to offer in that public comment, is that I think it's more of this non-categorical funding to help schools get students what they need and be able to service them.
So did I understand that right, that the court-ordered students you actually have to tap into 3 different sources of revenue in order to get that, which kind of complicates that? And are they reimbursed at the same level that that's what I was understanding?
Chairman, yes, they're not. So there's a difference when that comes in. A district place, we work with that district, we develop that contract. And I think that's something that I know our member districts are more aware of And I think that's why we've gotten pushback on some of our mill funds. They may not be as Representative Summers articulated. They have their different reasons, but then they feel like maybe they're filling in that and that cost difference, but it's really just how the system was set up, and didn't really think about that when they started allowing us taking these students. We didn't correct the process to make sure it worked. We just inherited them, and they have their own system, and we have that system. So yes, it is complicated because students don't look different to us, but how they come to us are funded and operated differently, and the requirements can change, and that makes it complicated.
Okay.
Mr. Chairman,
Go ahead.
I have a question of Daniel. So yeah, I think keeping to your facility together is one of your biggest challenges.
Yes.
Right? Keeping facilities, because obviously the Department of Education is not going to reimburse you for that. But what I don't understand is on special ed reimbursement, does it include anything for facilities?
For us,
Yes.
we build those into our fees. We try to build those in, and that's why those costs appear high, because if whatever the mill funds won't, we have to put some of those operational costs, or like I like to tell our districts, we need someone to mow our lawn. And I don't know how to charge a fee for that, but when you have 3 different parties wanting to figure out what part they're gonna pay, nobody wants to pay for those. People want to pay for the direct services costs. And as you know, there's a lot of other costs that go into operating a facility, maintaining good operations, and a lot of things to that.
So, Mr. Chairman, follow up. So, Daniel, without the mill levy, then the state would bear all of that cost, because you would have to increase your rate because you're not getting any of that mill levy. Without that mill levy, then the cost of the state's going to rise. Probably.
Yeah. And again, Chairman, Representative Summers, part of the reason that we brought this, I saw that as I started working for BOCES several years ago and looking for alternative funding streams that may not increase that bottom line to the state. Are there grants, are there federal dollars that we can come in and help offset this? Because it's high needs, and Senator Scott, to your point, it's costly, it's human capital. A superintendent talked about that, and that's a good point. What helps these students is the human capital that's expensive, to really make sure that we're creating a very safe and nurturing environment for students, to keep them safe. So it's, and then economy of scale is at, you're referencing those facilities, they're 100 beds, they're 140 beds. So when you look at economy of scale to a facility that can take 40 kids, I don't know what your capacity is, it's much different. So that, as you know, the smaller you are, the higher the costs come in high needs kids, so.
Okay. Further questions? Yes, Mr. Co-Chair.
Mr. Chairman, and I'm just playing around with ideas here. In the academic setting, you often see a concept of the indirect costs that's designed to support the institution as a whole, that are in addition to the specific costs that are incurred by, say, a research grant or whatnot. And Mr. Chairman, I'm playing with, maybe we need to do something like that, and maybe on a temporary basis to tide us over while our committee, and in particular Committee 10, tries to make sense out of the whole system. Because I'm scared we're going to get ourselves in trouble in the next year or two while we figure things out. And I wonder if that's something we ought to think about next time, putting in the bill that's in front of us, which is designed for improving the federal reimbursements opportunities. Maybe we ought to think about putting in an emergency general fund appropriation for indirect costs for a few years while this gets sorted out, because I'm afraid we've kicked the can down the road once too often already.
Yeah, I don't know the answer to that.
Sounds like a good idea to me.
Okay, anyone else? Okay, I think we're ready for WDE. I'm gonna have to go use the last one. This is my 3 o'clock break.
Okay. Wyoming Department, introduce yourselves and proceed.
Good afternoon, Mr. Chairman. My name is Wanda Maloney. I'm the Chief Policy Officer at the department. I'm here with Trent Carroll, who is the Chief Operations Officer. Shelley Hamill is the Chief Academic Officer, and Bill Pannell also supports in accreditation and support as a supervisor. We have several items to bring forward to you. The first is an overview of the charter school administration and the implementation that has occurred. We'll also go through the review and approval process of the charters.
Okay, wait a minute. So you're not talking on the topic we're in right now.
No. I
Oh, that's
think I need to
correct.
Make a motion, and we need to clear
Yeah,
all that other.
so just stay in place. Representative Summers.
So, Mr. Chairman, obviously, we went through a topic. Do you want to allow some public discussion
Yeah,
before I make a motion?
Anybody else on the topic of the boards of cooperative education and the whole placement problems for some of the special needs kids? Yes, ma'am. Could somebody in the State Department step aside for a moment so we can complete this?
Thank you, Mr. Chair. Janine Bayteski, I'm a trustee on Teton County School District's Board of Education. I think, a lot of this has been batted about, but what we're talking about is our highest need kids. This has been going on for years. And I think, Senator Scott, you're the only one that was here when Clarion Law told me some of the stories about why BOCES funding is like it is. And it's interesting that it's lived this long. I mean, we contribute about $650,000 with our 2/10 mill levy toward that. I think it's a shame that we haven't found a way to cohesively fund and adequately fund these kids. I see absolutely no issue with why we shouldn't allow them to apply for grants. Like I said, I just, want to put my passion out there. And, we talk about sending these kids out of state for placement. Just think about how sad that is. Sending them out of state for placement, these kids are going to lose ties with their families. Any tie that they had is going to be gone. You think families are going to be traveling to the East Coast to visit their kids every month? Likely not. So I just encourage that we take this topic seriously and we really try and come up with some way to address some of these really strong needs. Thank you.
I'm going to comment on that I think that's exactly right, but I do think we have to be careful because I suspect that a number of the kids that are being sent out of state now would be sent out of state even if we improved the funding quite a bit, simply because they have needs that we simply don't have the facilities and can't get because of volume issues. If we'd seen a fair number more going out of state, I think, well, we can probably bring some of these back, but I wonder with just 15.
I have no idea, honestly. So I thank you.
Okay. Now, anybody else? Anybody else? Representative Summers, do you have a?
Yeah, Mr. Chairman, I'd like to make a motion to draft House Bill 50 as a committee bill. And I was going to take out the state grant piece, but if we can leave it in for now, if we want to take it out later, we can. But basically, all this does is allow BOCES to be an LEA strictly for the purpose of grants. It wouldn't put them on the block grant, none of that. It would just be for grant purposes. And so that would be my motion to redraft this as a committee bill.
Okay, that's, the motion is a second. I will, right there. I did hear a second, didn't I? Okay. Anybody else on this? Anybody else? I will advise if this passes, I will ask an amendment to be drawn that allows us to pay a level of indirect cost on the reimbursements that we make to these BOCES for taking care of the school kids, that essentially tide us over, and couple that with an amendment asking Committee 10 to look at the whole spectrum, including providing the educational services for these severe kids, and be a general fund appropriation. The idea trying to be to force action out of the future legislatures. Have a look at it that we won't be able to accomplish now, but that's only if this motion passes. Anything further? Anything further? You've heard the motion. All those in favor say aye. Aye. Opposed? That carried. Mr. Co-Chairman, we've finished the BOCES with that motion. And now we're ready to hear from the State Department on charter schools.
Okay.
Thank you, Chairman Scott. My name is Wanda Maloney. I am the Chief Policy Officer. Again, I'm here with a host of support from the department. We have with us Trent Carroll, our Chief Operations Officer, Shelley Hamill, the Chief Academic Officer, and also Bill Panel, who supports with accreditation and support. We have several items within our memo. The first is information about the administration and implementation of the information, the review and the approval process, recommended statutory changes, and then we also have some additional considerations regarding funding and special education, and then authorizer functions that we'd like to walk through this afternoon. So in terms of our charter school administration and implementation, once the Chapter 32 rules were revised and approved by the governor, the application was also revised and improved, and it opened on July 15 for 1 month, and applications were accepted through August 15. The department did receive 3 applications, and I'll walk through those 3. The first is the Wyoming Classical Charter School, which is in Casper, and they propose to provide information and education for kindergarten through 12th grade. They also anticipate between 300 to 400 students that would be enrolled in the fall of 2023, beginning in grades K through 6. They would expand that over the next 5 years to include about 850 students, and they do not have a cap on enrollment. Some of in their application, they propose that their demographics are consistent with that of Natrona County School District, and they expect a teacher ratio of anywhere from 20:1 to 26:1 for their core classes. The department has reviewed their application and found that it meets all of the application and accreditation requirements, but WDE does have some additional areas of concern. One of those would be in unresolved issues with finance, and the second would be unresolved questions about special education. And as we go through each of the charters, you'll note that those are some of the same concerns for each of the charters. For the first year of the 2 operations, the Wyoming Classical Academy Charter School would occupy the former Mills Elementary School. And that was closed by Natrona County School District, and it's owned by the city of Mills. The second application came from Cheyenne Classical Charter School in Cheyenne. It proposes to provide a K through 12 education anywhere between 300 and 400 students. And again, that would be the enrollment for 2023. And that would begin with grades K through 6 for this next year and expanding to as many as 800 within the next 5 years. They do not have an enrollment cap. And again, their demographics are consistent with the demographics within Laramie County School District Number 1. Their teacher ratio would be between 20:1 and 25:1 for core classes. The department has reviewed their application. They do meet the components of the application and that of accreditation, but we do note 3 areas of possible concern. The first one is around unresolved issues with funding. The second would be unresolved questions around special education. And then thirdly, the applicant does not have a facility that's been arranged for the coming year. They have been currently searching with 1 to 2 temporary locations and have identified 3 potential churches, but in terms of actually entering into agreement, none of that has occurred at this point. The third applicant was the Prairie View Community School in Chugwater, and they would provide kindergarten through 12th grade education. Again, their current enrollment, and this is based on surveys, based on information, letters of intent, they would enroll between 57 to 80 students for the fall of 2023. And again, their demographics are consistent with the Chugwater community. And they would propose to maintain class sizes of 16:1. The department has reviewed their applications. And again, they do meet all the application and accreditation requirements. There are 2 areas of possible concern that we'd like to bring forward. One is around unresolved funding and additionally special education. With that, I will give you just a couple more pieces of information around the review and approval process. When the application comes into the department takes 10 days to review the applications, and then if they find any of the components are not complete, we send those back out. Then the charter schools have 15 days to make any changes or revisions, submit those again. Once we have completely gone through them, we do send them on to the State Loan Investment Board, and their process then is to have a public meeting, and they also hold applicant interviews as part of their final approval. And then if there are any applications, and we did actually have one application that came to us, and this was submitted with the district as the intended authorizer. And in that case, we submit those directly to the district. That was in Casper. The final piece of it then is if any of the applications come to us, and we actually did have one from Prairie View with waiver requests, and what they were requesting was less than 175 days. And so those waiver requests, after approval from the SLIB board, if they're authorized, they go then to the State Board of Education for approval of the waiver. And with that, I will stop and to see if there's any additional questions before moving into statutory changes.
Okay, any questions from the committee? Senator Ellis.
Thank you, I just hit my knee. Sorry, it really hurt. On the days for the waiver, how is that based in statute or with your rules where you have some school districts that do the 5-day school week versus some districts that have moved to the 4-day?
Thank you, Chairman. Senator Ellis, there's a requirement for having 175 days of students, and then also that if students or if districts want to go outside of that, they do apply for an alternative calendar. So they still could have a 4-day week, and this is what they are proposing. I'm not sure I'm answering your question, but they are proposing a 4-day week.
I didn't know that, but that's kind of what I was getting after. Thank you.
But those, that could also be with extended hours, is that correct? I mean, it's longer day than the
Certainly,
ordinary school
Chairman.
day, if they do that, okay. Reading this over, there's a phrase in here that I don't understand, Western traditions and cardinal virtues. What do we mean by that?
Thank you, Representative Paxton. I'm going to turn that over to Bill Panel, who has done some extensive work in reviewing the applications to.
Bill?
Mr. Chairman, Representative Pax, good to see you today.
Yeah, good to see you again.
I looked that up and I think cardinal virtues, there are several different definitions of cardinal virtues, and I guess I won't go into how Hillsdale College defines it, but I think it probably means moral values. Western tradition, I believe, probably means American heritage.
Okay. All right, questions from the committee? Okay, proceed.
Mr. Chairman, I'll go on then to the recommended statutory changes. The first one is in relation to the appeal process, and you'll note in statute 21.3.310, the appeal process was repealed effective July 1st, 2022. There is a section in Wyoming statute 21.307D that still refers to Wyoming statute 21.3.310. So that would be just a small housekeeping item. The second item is around insurance, and this is within Wyoming statute 21.3.307. And the current language would also anticipate that an agreement has already been put in place. This is not the case as we work through and review the applications. Our recommendation from the department would be that the language be changed to a proposed agreement or a summary of a proposed agreement. And then the last statutory change, in working with the state board receives an annual report from charter schools. And what we would like to see changed with the state board is in 21.3.312, and have it define the purpose of the annual report so that it would actually address what are the purposes of the charter. It would include information about its mission, the curriculum, student learning results, and then any waivers and how they might be contributing to the success of the school. This would provide additional information as the state board works with traditional schools, and if there were benefits that would actually support a traditional school.
Yes, go ahead.
So under the student learning results, would these students be required to take what would be whatever standardized tests that are given in our public schools? Or would there be a different standard of student learning results?
Mr. Chairman and Representative Newsom, my understanding is that they are required to take the state assessments and also are held to the same accountability measures.
Okay, other questions? Yes.
Thank you,
Senator
Mr.
Ellis.
Chairman. In the second recommendation, did you have conversations about if it's a charter authorized by the SLIB, that they would annually report to the SLIB rather than the state board? I'm just kind of curious, as that was the whole point of having separate authorizers, and with the state board not being involved in that authorization process. I was just curious what your discussion was with this recommendation.
Mr. Chairman, Senator Ellis, we did have discussions about that, and we felt that it would be important, it would be interesting to have the authorizer providing that explanation and providing that report, and we felt that it would be beneficial to come directly from the charter schools that were operating.
Okay, further questions?
Mr. Chairman, I don't know that that answered it. So if a charter school is authorized by the SLIB, they would still annually report to the State Board of Education instead of to the SLIB? That was the question I had. Why wouldn't they report to the SLIB?
And in terms of Chairman Scott, Senator Ellis, In the way it does stand, they would actually go through the authorizer, and then the authorizer then, my understanding is then would bring that report forward, unless I'm understanding this differently.
Senator Scott?
Mr. Chairman, it seems to me like this is just a simplification of that, trying to avoid putting unnecessary work on the slip board. Let them do it directly to the state board. I think in terms of report and getting it compiled with all the other things, that's probably the appropriate way here.
Follow up? Are you okay? All right. Senator Salazar?
Thank you, Mr. Chairman. So I'm just slow. So it would go to it would not go to the SLIB, it would go to the Department of Education then?
And
Go ahead.
Mr. Chairman, am I right in understanding that the state board's role is simply compiling and making available the information, and is not taking any management action between it and the charter school once it gets the report? Is that correct?
Mr. Chairman, the charter would complete the report. They would submit it. It typically goes through the department, and we then do bring it forward to the State Board of Education for their review. And currently, the State Board of Education has no other authorization or no recommendations. It's just a review process of something that's made available for them.
Okay. Further questions? All right. Proceed.
The next section is around additional considerations. And through the process of looking at the charter applications and the review of these, there are some additional things that have resulted in potentially unintended consequences. And the first one is around funding. The second is around special education. And then lastly, the authorizer. And so with that, I will turn over the section regarding funding to our Chief Operations Officer, Trent Carroll.
Thank you, Mr. Chairman. Trent Carroll, Wyoming Department of Education. I just wanted to touch briefly on a couple of things, make sure that you're aware of them. So as we've delved a little more deeply into the charter school application process, and specifically that authorization through the SLIB, we've identified at least a question. I don't know if it's a concern. I guess that's for you to decide, but it's a question, and it's about the funding mechanism for a charter school. So I want to highlight I'll just kind of run through and provide a little bit of context around the current provisions in statute for providing a charter school with their funding. So this is under Wyoming Statute 21.3.314. There are multiple options, and for my presentation, I'll group these into two buckets. So bucket A would assume that the district and the charter school enter into a funding agreement, and bucket B would assume that there is no agreement. So under this bucket A label, the agreement negotiations may follow the statute provisions, and that the charter school is entitled to 100% of the amount generated in the funding model, so that would exclude any of the district level resources. But they would be entitled to that, and then they would also be entitled to a proportional amount of the major maintenance funding generated for the school district. And then lastly, in bucket A, in lieu of what I just described, the district and the charter can negotiate a budget, basically budget that they agree on, doesn't have to follow those preceding items. They can just come to an agreement, and then that would govern the funding. So under bucket B, this is 21.3.314 subsection F. This outlines the required process when the district and the charter school do not reach an agreement. Basically, it requires a reduction in funding for both the district and the charter school, reduces those amounts to 80% or 65% for a full-time virtual charter school. So as you can see, these different funding scenarios would be highly dependent on the working relationship between the charter school and the district. So with that context, the question that we've identified is really around the logistics of the funding. So as you'll probably all know, the WDE manages the funding model. That means that we determine the school foundation program guarantee amount for each district,
and then we would disperse the funds to the entitlement districts and collect funds back from recapture districts. Under all of the funding scenarios that I just explained, we envision the funding going through the school district. So you might have noticed on page 3 of our memo, there was a question in there about the intent and whether or not there was intent that the charter school funding under this scenario where there isn't an agreement with their district would flow through the SLIB directly to the charter school. That's not what we're planning to do. So if, when you read that question, you answered, yeah, that's what we're expecting, then we might want to talk about that. We just don't think logistically that would work. So that was one piece. There's kind of an opportunity here maybe for a perception that a charter school authorized through SLIB would be more independent per se than another school in the district. That gets a little bit murky, but for funding purposes, when we're looking at the model, it's all tied to the district. So that was the first piece that we wanted to bring to your attention. The second item is specific to transportation and special education.
Okay. Senator, go ahead.
Thanks, Mr. Chairman. I just want to make sure that I understood the implication there. So the, as drafted with 314, there's the implication that it would flow with 314F, that it would flow through SLIB directly to the charter school. But you're saying you're not going to do that because it's unworkable, and instead you would flow it from state to school district. SLIB wouldn't be involved in the funding flow. At least that's the intent, but it sounds like that would require a statutory change to facilitate. Is that accurate?
Go ahead.
Mr. Chairman, Senator Rothfuss, the statute isn't entirely clear. There have been some questions about the funding flow. Our interpretation is that it would flow to the district under all scenarios. We wanted to bring this up in case there was a different expectation kind of floating out there. It could be vetted, and then if different instruction were necessary, then we would be aware of that. But as we read the statute now, there's a district amount that should be calculated, there's a school level amount that should be calculated, and that entire amount would flow through the district and then to the charter school.
Mr. Chairman, a quick follow-up. So is that in disregard to the reduced amount, or is that the reduced amount? I mean, are you implementing F Romanet 1, or are you just ignoring F Romanet 1 and just going with the above provisions?
Mr. Chairman and Senator Rothfuss, no, we would not be ignoring that. So as I mentioned earlier, there would be a reduction to 80% for a regular charter school or 65% for a full-time virtual if there isn't an agreement in place, and we would follow the statute in that regard.
Okay, so Mr. Chairman, I think I'm understanding it now. So you're going to follow basically the funding mechanism that was previously in place in 314A through E that applied to that. If there is no specific agreement and it falls to the funding provision in F Romanet 1, you're still going to use the mechanism for funding, but you'll reduce the value.
Mr. Chairman and Senator Rothfuss, that is correct.
Gotcha, thank you.
Okay.
Mr. Chairman.
Mr. Co-Chairman.
As one responsible for this law, that was the intention. So I think they've discerned the intention correctly, and I think I think you're correct in the way you're going to do it. The one thing I would say on the reimbursements for transportation special education, the assumption in drafting that was that with the court decisions there, that those would flow through the charter school as appropriate, and you'd use the same mechanism of getting the costs and reimbursing them just as you would for a school district. Now, it may be that particularly some of the transportation, they'll come to an agreement, and that'll make it even easier.
Mr. Chairman and Senator Scott, thank you. So the main issue there that we wanted to bring up is that under this scenario where the charter school and the district do not have an agreement for the provision of those services, we do not believe that the current statute provides a mechanism for reimbursement to the charter school. It's a district level reimbursement, and so that again is our interpretation. Wanted to make sure that you were aware of that.
Go ahead.
Mr. Chairman, The intent of the legislation was that they would get those reimbursements, and in that case, you'd essentially treat the charter schools if it was a district. If necessary, we could, and we're gonna have, I think, a technical corrections bill, we could put that in to make sure they do get those reimbursements when it's appropriate. And I think it'll be easier all around if they make a deal with the school district, but if you know, there's hard feelings and somebody won't, we need to have the backup provision. So, Mr. Chairman, that's something we could add to the technical corrections bill. Matt and Tanya, do you understand what I'm talking about?
Mr. Chairman, are you talking about the revisers bill?
No, I'm talking about, we're gonna have a technical corrections bill on charter schools, I think, with the ones they've identified in the earlier paragraphs. It's not appropriate for a reviser's bill. And if so, if the district and the charter school can't come to an agreement on reimbursement for transportation and special education costs, we'll need to provide that the charter school gets reimbursed in the same manner as the school district. That would solve your problem, would it not?
Yeah, Mr. Chairman and Senator Scott, the section in statute that I think might create a little bit of confusion. So this is 21.3.314, and then subsection C and Romanet 1. And this is the section that talks about the charter school being entitled to 100% of the funding. But then it says, less any district level amounts generated by the charter school's memberships, and then it references 21.13.309M, and less amounts specified under 21.13.309M5E, which is the section that governs the reimbursements of transportation and special education. So again, it's just a little bit, we wanted to make sure that you were aware of that. And in this scenario where there isn't an agreement between the school district and the charter school for the provision of special ed services, we would need a mechanism to cover those costs if that was the intent.
Mr. Panel, you had your hand up a while ago. Do you want to weigh in?
Probably want to, in addition to transportation and special education, also include nutrition in that discussion. Nutrition programs in that discussion as well.
Okay.
Mr. Chairman.
Yes, go ahead.
And that would be acceptable to y'all, would it not, that including the nutrition ones? Are you talking state funds or federal funds?
Mr. Chairman, the state does not provide a reimbursement for nutrition funds. It's a national school lunch program that the state administers through the Wyoming Department of Education. School districts participate. So districts have their own food service programs that they operate. And I'm trying to understand the direction that you're directing the charter schools to.
Well, Mr. Chairman, that's why I asked, was this federal or state funds? They ought to be able to get their share of the federal funds if necessary. But we don't want to put any special thing in that we aren't getting from the feds.
Mr. Chairman and Senator Scott, we've been reviewing our different federal programs to see if there are any obstacles there. And the next section in our presentation here will actually talk about one of those potential obstacles with regard to special education, but we will certainly include the USDA nutrition programs in that review as well.
I think it sounds like we don't need to, until that review is complete, we don't need to talk about any drafting here. I would ask, Mr. Chairman, if I may, one question. You talked several times about the charter school getting 100% reimbursement. The intent of that negotiation with the district is, then the charter school people would be counted as part of the district ADM, get a reimbursement, and charter school wouldn't necessarily be entitled to all of it. That's a deal they negotiate with the district. And so there's no mandate that the district give the charter school 100% of what it gets. And the envisioning was that there would be an agreement as to how much the charter school was going to get and how much services they were going to get from the district. And that's something that those two parties could negotiate together. Does that correspond with your understanding of it?
Mr. Chairman and Senator Scott, so our interpretation is that there are different options here. So one option would be, as you described, the district and the charter school can negotiate a budget, whatever they want that to look like. Statute does reference that when they're going into those negotiations, that the charter school is entitled to 100% of the school level amount. So that's what's currently in statute, and then there's also a provision that allows for them to negotiate a specific budget.
Mr. Chairman,
Go ahead.
as I remember it, the 100% applies to, the state's going to reimburse at the same level that it's reimbursing the school district. But when the school district and the charter school negotiate a budget, how much of that flows through is the subject of that negotiation. And the envisioning is that the school district will probably retain some of it for the services they provide. Do you think we need to change the statute to implement that?
Mr. Chairman and Senator Scott, so I guess I would just refer back to this subsection C, Romanet 1. So this is the section that's describing the charter school contract. And it says, so under C, the charter school and the school district shall agree on funding and any services. This is all under the assumption that they're coming to an agreement. And then under Romanet 1, the charter school shall be entitled to the benefit of 100% of the foundation program amount computed under 2113-309M. So that would be the funding model. And then it prescribes less than any district level amounts generated by the school's membership and less the reimbursements. And then the second one talks about the 100% of the school district major maintenance. 3 talks about salary adjustments. And then D talks about the opportunity to contract with the school district for centralized services. And then E is where we get to, I think, what you're referring to, which is in lieu of A for subsection C through D, this district and the charter school may by mutual agreement fund the charter school through a specific budget for the charter school. So I think there are different scenarios that can be explored. And ultimately, an agreement can be created with whatever terms the parties can agree to.
Okay. More questions on that? You're still studying up on it?
I'm going to have to look this one up.
Okay. All right, let's proceed then.
So, Mr. Chairman, unless there are any other questions, I'll hand it off to Shelley Hamill for the special education section.
Okay, go ahead.
Mr. Chairman, Shelley Hamill, the Wyoming Department of Education. The last topic that we want to bring to you for consideration is around the area of special education. The 3 concerns that I'm going to outline for you are based in the federal definition, the federal IDEA definition of an LEA, or a local education agency. And it specifically uses language that identifies the SLIB as the LEA because it is the authorizer of the charter school. So there are 3 main areas that come to concern. One is first, the LEA's responsibility of the provision of FAPE and SLIB's ability to oversee that. So we all know that an LEA or a district receives funding from the state, both federal funds and state funds, to oversee the implementation of FAPE. They're charged with the responsibility of implementing a system that's both compliant with procedural requirements and programmatic implementation. So that would be all the way, everything, including providing special education and related services to the child find responsibilities, the development of an electronic system to track IEPs and all the related paperwork, the comprehensive assessments, et cetera. They'd be required as other LEAs to hire and supervise appropriate staff both certified and non-certified, for the provision of those related services and special education services, such as the special education teacher, OTs, PTs, speech language pathologists, school psychologists, special education counselors, adaptive physical educators, and case managers in some situations. And then at the building level, then they would be looking at the general oversight of the implementation of that program and the general provision of FAPE to specific students. Were they indeed receiving the FAPE package that was identified through those processes and identified in their individualized education program? So if the SLIB then is recognized as the authorizing agent and then the LEA by federal definition, the question is, how would the SLIB oversee that these procedures and processes occur at the charter school level?
Yes, go ahead, Senator.
Thank you, Mr. Chairman. My question is, why wouldn't the charter school themselves be their own independent LEA and do their own paperwork and take care of all that on their own, take out the middleman and just keep SLIB out of it, do the reporting to SLIB and WDE, and let them be their own LEA? Has that been contemplated?
Go ahead.
Mr. Chairman, Senator Beitman, I don't think that the statute conceptualizes them as their own LEA.
Okay.
Okay, the next area is around some of the responsibilities of the WDE as the state educational agency. The state educational agency then, as the recipient of those federal dollars, is required to ensure that each child in the state or each student that is identified and qualifies for special education related services actually receives FAPE. And we make sure that we meet that requirement through monitoring processes. So the question has arisen, would it therefore then be appropriate for the WDE to monitor the SLIB as the authorizing LEA? And if any non-compliance were found at any of those charter schools, would the SLIB be prepared to oversee that corrective action plan? And if not the SLIB, then who? And then the final concern that we'd like to bring forward is, additionally under IDEA, one of the rights that parents of students with disabilities is the right to ask the state for dispute resolution services. And the WDE does provide these to parents through 3 different mediums, either mediation, state complaint investigation, or due process hearings. And in the case that a parent found that they were in disagreement with their charter school that was authorized through the SLIB, we're wondering who would be responsible for defending or presenting information about that specific case through either the monitoring or the complaint investigation or the due process hearing. Would SLIB be prepared to do that?
Okay. Do you have a question, Mr. Co-Chair?
I guess really my question is about the same way that Senator Beitman just articulated. You know, it seems to me that the LEA is the charter school and we ought to treat them that way and proceed. Now, if they have a different agreement with the district, that's fine.
Representative Brown.
Mr. Chairman, thank you. While I understand the intent of what the chairman is trying to say, I think that would be akin to saying, and correct me if I'm wrong, that each individual elementary school would be their own LEA as opposed to reporting back to their own district. Am I correct in that?
Mr. Chairman, that's correct, Representative Brown.
Senator Rothfuss, did you have a?
And Mr. Chairman, again, even if we were to work this out, I think the reality is it gets back into the need for the technical correction. Just because the intent was there, this was a piece of legislation that I think there were a lot of concerns with the way it was structured around the SLIB for this very reason, that it was going to be awkward from an administrative standpoint and would cause these problems. So here we are and we're seeing these problems. The reality is they're clearly doing their best to try and make this work, but I think this is a real structural problem from the IDEA standpoint, where if there isn't a clarification of an appropriate alternative LEA, it's going to cause real problems. And I'm not saying that good Senator Beitman's idea wouldn't work. It may well, and it may be a charter school board or something. I don't really know exactly how to structure that, but you do have to have that separation of your LEA from the entity to be compliant. So maybe there's a solution, but it's going to require legislation. Thank you, Mr. Chairman.
Representative Summers.
Mr. Chairman, and you go on down and it looks like your solution is to force it on districts. That's, you know, we don't want the responsibility, so let's push it down and give it to the district. So I'm not a big fan of the solution that's written in here, and that's the only solution that was provided.
Mr. Chairman,
ahead.
Representative Summers, I think that we have limited solutions. The federal IDA language doesn't entertain the opportunity to flow funds directly to, their federal funds directly to a school. And so that would be complicated at best. We do have another situation in our state where we have a 49th district with the early intervention education program through the BHD for those early childhood special
Mr. Chairman, I
education
can't
dollars.
hear. Can we ask the audience to refrain, take private conversations to the hall, please?
Sorry, and that does cause considerable complications in working with a sister agency as the LEA. I'm unsure how we would work with a private charter school if they were authorized as an LEA. They'd need to be set up and prepared to participate in all the reporting responsibilities required by the federal government, by the state, et cetera.
Go ahead.
I'm curious because we talk about the authorizer, and that's really what the original intent of last year's bill was trying to find a medium ground for an authorizer that was outside of the district. But when we start talking about an authorizer, and if we say that the LEA is going to be the school district or the charter school itself, that's like me walking out and saying, well, I'm going to be the governor, and just proclaiming that I get to be the governor, right? I mean, I can't just self-proclaim that I'm going to be a good school and walk away. That's the entire importance of having an LEA, is to, in essence, make sure that there's a buffer and that there's at least some level of accountability other than just the school. Am I right on that?
Chairman, Representative, it would be awkward to have the school itself be its own authorizer and then accept those responsibilities of the authorizer.
Let's go over to Senator Beitman first.
Well, thank you, Mr. Chairman. Correct me if I'm wrong, though, but that sounds like what school districts do now, right? What's the difference between a public school having to receive federal funds, do reporting, assure delivery of acceptable services, provide training in compliance with federal laws, conduct audits, and report to state and federal education units? That's what local school districts do. Why wouldn't a charter school be able to do it? What's the difference?
Anyone want to try to answer that?
Mr. Chairman, Senator Beitman, that one is a challenging question. I think that, I guess as I consider the structure of a school district, there's a central office administration that oversees all of those types of regulatory services, et cetera, and responsibilities and requirements. And then there are schools within those districts that meet the needs of students through, by following those regulations and implementing those. And I don't know that any of the charter schools are set up in a way that they have both of those layers of structure. And there may be more nuances to that I'm thinking of just in the moment, certainly.
I'm thinking that maybe we need the LSO to help us understand how the federal law works, and I don't know if that requires some research or what, so that we have a better idea of exactly what we can and can't do.
Mr. Chairman, this is not an issue that I have researched. Just a quick, search online. Other states are dedicating charter schools as local education associations, but I don't have any legal advice to give you on the spot today. I think the Department of Education, you know, they're probably an expert in this area, but I certainly can research it and perhaps get you an answer tomorrow.
All right.
And Mr. Chairman, I can tell you, as far as the funding goes, what they've outlined, the statutes don't contemplate the SLIB getting the money. The statutes contemplate the funding flowing through the school district and reaching some sort of agreement between the district and the charter school. And then in the event that an agreement cannot be reached, there's sort of a fail-safe provision, which is the 80% and the 65% if it's a virtual education program. To Mr. Carroll's point, there is an exclusion of the reimbursable expenditures for special education, transportation, isolation, and maintenance, and I can't remember the others off the top of my head, tuition, teacher extra compensation. So.
Repeat that, please, Mr. Chairman, that last piece.
So there is an exclusion.
Isn't, I can't hear you.
There is an exclusion of district reimbursable expenditures, which include special education, transportation, isolation and maintenance, tuition, teacher extra compensation, those items that are outlined in 309 MVE.
So, Mr. Chairman?
Go ahead.
So, Mr. Chairman, so Tanya, those have to be found in a different modality, right? So in other words, those are not contemplated or not placed into the statute, so they have to be done in a different mechanism than.
I think the charter school could apply to the district and they could reach an agreement regarding those reimbursable expenditures. I think the point that Mr. Carroll is making is with regard to in the event an agreement cannot be reached and subsection F is triggered under 314. Mr. Carroll, is that correct?
Okay.
So just another quick question.
Go ahead.
So Tanya, is there a reason, I mean, obviously we can create statute any way we want, but the idea that Senator Beitman had that in that case, then a charter school becomes an LEA, that's no different than a Matizzi. They're a one school outfit, one school show, so theoretically you could have a board and they could be in that case. I mean, I guess you could create that. How's it in other states? I mean, this isn't a new territory. You know, or do you have any idea, Tanya?
Mr. Chairman, I did look at this just briefly this morning, and I know there are other states that are designating charter schools as LEAs, but I did not have an opportunity to look at their authorizing statutes to see what those, what revisions might be necessary to accomplish that goal. And in looking at the definition under IDEA, I mean, it specifically notes charter schools as an LEA, but again, I would rely on the Department of Education and their expertise in this arena.
Senator Ellis.
Mr. Chairman, just to recall, we chose the SLIB because there was an acknowledgement that we only wanted 3 in the state to have a bit of a pilot. And so we were trying to think of an entity without creating a whole new charter school commission. And so I think other states, if you look at it, they think through a little bit more of this because they set up an entire agency. And so that was our concern, was set, more FTEs, more appointed bodies as the separate statewide authorizer. So I think there's some workarounds, but I just want to remind everyone, this is for 3. And if we want to expand it and open it up more, then I think we could probably have some better solutions. But right now, I think we just need to find the right Band-Aid until we decide what we want to do.
Yep.
Unless we want to open it up, which I think some people would like to do, and I'm guessing others wouldn't. So just some food for
Alright.
thought.
WD, do you have more you'd like to finish this out here? Yes.
I guess just to clarify, I would ask then if either the board of the charter school or the charter school itself ends up satisfactory as an LEA, and it's so declared through statute, so maybe we have to tweak something. Well, I guess I'll ask, would we have to tweak something? It seems like we would, that we'd have to have a technical correction for that. Is that accurate in your view?
Mr. Chairman, could you repeat that? I couldn't hear the last
Yeah.
part.
My apologies. I'll get a little closer to the mic. If the charter school or the charter school board is an acceptable LEA under IDEA and at the federal level, if that is the case, as is suggested, would we have to change statute through a technical correction to facilitate designating them as the LEA? So, okay. And,
Chairman,
go ahead.
Yeah, and I think it would be a little bit more complicated than that when it comes to the federal funds, much like us flowing funds to that 49th district for the 3 to 5-year-olds. We had to work with our federal partners to establish a process and then have it codified in statute. Because the federal funds are determined based on a geographical area.
Okay, Mr. Chairman, but following up on that, but it sounds like that has been worked through for the 49th district, and it would be a similar process. So if there were the technical correction through statute, that would probably provide a sufficient remedy for a solution for IDEA. Is that accurate?
Mr. Chairman, I think so. I think we could work through that.
Thank you.
Okay. Mr. Co-Chair.
Mr. Chairman, I think we've made progress. I think that's the solution to this one, is just to include that technical correction in a technical corrections bill. And Mr. Chairman, I think that's what we ought to do. Do you want to take public comment first before you get a motion?
Well, do we want to delay until tomorrow when we get a little more information from our staff, our LSO staff?
Mr.
before we-
Chairman?
Yes.
We have quite a few people in the audience. There might be someone who has some information about how other
Yeah.
states have tackled this.
Well, we're going to do public testimony after the WDA finishes, WEA. Okay. All right, with that, we are at public comments, public testimony. Anyone want to testify? Looks like we already have some people signed up, so.
Jed, the numbers guy.
Thank you, Mr. Chairman. Jed Ciccarelli, Chief Financial Officer for Laramie County School District 1. Considering the late hour, I'll be very brief. You're probably aware that Laramie School District 1 is one of 3 school districts currently operating charter schools in the state of Wyoming. Over the past 10 years, we've certainly learned from that experience and have made some necessary adjustments as we develop that process and that work in collaboration with those 2 schools. I appreciate the department bringing forward some of the concerns that we expressed early as we were working through this process. Some of them, we certainly feel that there could be a lot of clarity, specifically the funding piece. We wouldn't be surprised to hear us say that we disagree with the proposal that would delegate the SLIB's responsibility to the school districts. Perhaps the easier, more appropriate answer is what's being discussed by the committee now. Senator Beitman's suggestion that we at least explore the opportunity to designate those charter schools as LEAs. There are a number of different areas that could benefit those charter schools in particular. The flow through of federal funds that was mentioned earlier is certainly one of those pieces that would be a consideration. And certainly your staff will have more reliable information and analysis to provide later. But the current federal regulations do contemplate really 3 different structures for charter schools and how they're recognized either as an LEA designated by the state or a governing body, as operating as a school within the school district, or a third category where it doesn't fit in any of those categories. And the state education agency has to designate some type of provision of FAPE. Mr. Chairman, just as I wrap up a couple of comments.
Go ahead. I'm sorry.
Mr. Chairman, thank you. So Jed, you kind of swallowed that last option, but would you expand on what you said and what that means?
Yes, Mr. Chairman, Representative Summers, essentially what that would do is have that third category where the school isn't classified as a public school operating within a district, designated as an LEA by the state through some type of law or statutory requirement. What that third category is kind of the catch-all, if you will, that allows the State Department of Education to delegate that authority or determine who is responsible for ensuring FAPE of that charter school. Again, I think there are people who are a lot more versed on those pieces of FAPE and the delivery of special education services, but it does tie into the funding and the operations side for us in particular. Some of the same issues that you've addressed now also impact how we provide funding to existing charter schools. Through Department of Education directives, right now with special education in particular, we have to contract with our charter schools for them to provide special education services with their staff, which in turn requires us to front that cost for a full year before we are reimbursed. And that's the only way, the only mechanism we came up with working with the Department of Education to access those special education dollars if we weren't providing those services directly. So that would alleviate that concern on existing charter schools as well. And Mr. Chairman, just to add a couple of additional points, certainly facilities is another question. Our two charter schools in Cheyenne do receive state funding for their lease. The question over access to major maintenance funding has usually been moot, at least with our charter schools, because they have full service leases as required through their agreement with the State Construction Department. Our district flows through that money as well as federal funds. It's unclear at this time if the proposed SLIB charter schools will or intend to access federal funds, but all of these issues might seem trivial, but to provide a real life example, our charter schools are designated as component units of Laramie School District 1. And that's through General Accounting Standards Board's classification of what a component unit is. Generally speaking, there's two major determining factors. The first would be the level of oversight and accountability that the local or the primary government has. And the second would be the financial dependency. So it's unclear at this point in time if the SLIB is the authorizer and the school district is flowing through the funds. Where does that leave that particular charter school for reporting purposes? And again, it might seem trivial. In the past, we have had charter schools with audit findings that have tipped our district into a high-risk auditee status. As a result, there are consequences as far as incorporating their financials into a school districts. And so, Mr. Chairman, happy to address any questions that you may have on how we operate our charter schools or any other questions.
Okay, any more questions from the committee? Yes, go ahead.
Mr. Chairman, the intent of the bill, and I thought the way we had it written, was that the existing charter schools would remain functioning exactly the way they are now, that this bill wouldn't change those at all. What I heard you saying is maybe we can simplify the special education one for the existing ones too. Is that correct?
Mr. Chairman, correct. The same barrier that the Department of Education explained for new charter schools exists for existing charter schools as well for accessing special education dollars.
Okay, Mr. Chairman, so we can probably solve two problems with one stone there.
Possibility. Okay, anyone else? Okay, thank you. Welcome back.
Mr. Chairman, members of the committee, Kevin Mitchell, Executive Director of the Wyoming Association of School Administrators. So I have questions that I think we've tried to ask. This LEA is kind of a real dilemma. I'm guessing that there's a current definition of an LEA in Wyoming, and I'm just going to guess it's a school district governed by locally elected officials. And just to say somebody else can be an LEA, I think there's different ramifications for that. So one, the question would they become a new school district? Because if that's what the definition is now, if not, then if you change the definition, I guess you would add something, or then now the current school districts have a new definition of who they are and how they are run as well. So the whole idea, it seems to me like, is this process has completely disregarded local elected officials. So there's not even a conversation with the school district to apply, and then a group of state elected officials approve it, and then you're going to say, and by the way, this is now your new school. And you're asking them to come up with an agreement, but I've never seen a template of agreement. I don't even know what that looks like. But the third option was, if they don't come to an agreement, then they just get a certain percentage of funding, if I'm correct. But do they become an LEA now? Still haven't figured out whether they're going to be an LEA or not an LEA if there's not an agreement reached. And who is the authority over that school? I guess and I'm not sure how that board is developed. They're appointed or something. And then is the funding knowledgeable that we all understand that there's been many conversations about the lack of revenue for funding in the state of Wyoming, and we always kind of hear 300 million, but each one of these schools is going to create new need for revenue funding. A new school itself in the current funding model generates a need for revenue. So it's not just taking some money from the school district that didn't have any actual authority to do anything about this school and providing it. The school itself in the funding model generates money, and so does the facility generates money. So I'm not sure that everybody knows that there's going to be a cost to taxpayers, and I'm okay with that. Just that the transparency of, we're just doing this and it's not going to cost any money. I'm not sure that that's been discussed very wide, that we don't have enough revenue for the current funding system, but we're possibly adding at least 3, maybe 4 new schools to that system statewide. So I haven't heard that discussion amongst legislators either, about where that funding is going to come from when we don't have the revenue for what we're doing now. And lastly, there was a conversation about what rules and things the charter schools have to follow. That was kind of a blanket statement. They have to follow all the rules that the public education schools, other public education schools, because I think they're public as well. They just have a different name in their charter. If they're funded by the state of Wyoming, they're a public school. Do they have to be accredited every 5 years and follow all the chapter, 40-some chapters of the Wyoming Department of Ed and the entire green book for education and statutes in the state of Wyoming? Do those schools have to follow that? So if they're just an LEA by themselves, they really need to have some type of a district structure then to make sure that they're following all the rules of state laws and WDE rules. So I would stand for any questions.
Okay, questions for Kevin? Yes.
So, Mr. Chairman, thank you. So Kevin, an LEA can be defined in different manner. We just made a motion for a bill, right?
We just had that conversation with BOCES.
Yeah, we just had that conversation. So it's how you define the LEA. If you're defining in this specific instance, when you can't reach an agreement, an LEA is formed for special education purposes, then you just have to define that. I assume we can do that, but you have to be very specific on that. So it doesn't apply to everything else that you're talking about. But I think you raise a good point. When you create another school, it's going to, in the funding model, it's going to generate money, and that money has to come from somewhere.
Okay, anyone else?
Jim,
Go ahead.
I think specifically we need to look at the provisions of the charter school on this. They're going to be funded either in a budget with their local school district, which would then depend on the revenue that's available to that local school district. You count them as part of the system. And that's not, I don't think, going to lead to any net increase, or they're going to get 80% of that. So I don't think the analysis is accurate that it's going to cost more money. But that's my reading of the legislation and the way I think it'll work.
Okay,
Mr. Chairman.
yes.
Mr. Chairman, and I haven't gone back through all the statutes we created, but I guess the existing charter schools, so this is my question to Kevin. So the existing charter schools we have in the state of Wyoming, those schools generate, they generate money from the model, just like any other school within that district. Is that correct?
I should refer that to someone else. I'm saying yes, because where's the money going to come from? When I'm saying the school generates money, it's going to have a principal, administrative assistant, a librarian, a library that you need to put books into. And those are not coming from necessarily going to come, they're not going to shut down a school, I guess a district, especially if there's not an agreement to work together. Where's the money? The school itself, students generate money, the school itself generates money, buildings generate money in the model. So when a district starts a new school, that school generates money for itself. And the school district gets that money.
Mr. Chairman, Kevin said he didn't know for sure, but Jed would know because his school district has a charter school. So if Jed would answer the question, are you allocated money in the model with that charter school, just as if you were allocated money for any other school you had?
Mr. Chairman, that's correct. With the added note that charter schools are. Thank you, Mr. Chairman. To restate, that is correct. The charter schools are funded as if they were any other public school within our district, currently existing in our charter or in our school district. The added note that there is additional funding for the first years of operation for newly created charter schools. They're funded in the first year of operation, which is an exception to a publicly funded school, a school district funded school that waits a full year before the funding model adjusts. And they also receive double funding for the first years of operation and for grade advancements.
Okay. Thank you. Anyone else? Okay. Anything else, Kevin? All right. Anyone else like to testify? Yes.
Good afternoon, Mr. Chairman and members of the committee. I'm Lisa Grover. I represent the National Alliance for Public Charter Schools, and I hail from Albuquerque, New Mexico. We stand as a resource to members of the committee and indeed the legislature. I'd like to offer a few thoughts on the funding model and LEA status of charter schools. And there are 46 states with charter school legislation. I don't have the count in front of me, but I would venture more than half allow a charter school to either be an LEA or a component school within the school district. For purposes of funding, if a charter school is an LEA, they bear all responsibilities for that funding, including special education funding. So if the charter school is directly receiving federal funds, in particular special education funds, then they are solely responsible for the delivery of those services according to state and federal law. Most state laws that allow charter schools to be an LEA, if not all state laws, I don't have the information in front of me, they simply do act as their own mini district, but without any additional costs. As the superintendent of Laramie Public Schools stated, students in a charter school generate funding under the state formula as well as under any federal dollars that those students are generating by virtue of their status, whether it's free and reduced lunch or ELL students, whatever it may be. So the additional funding is not, I don't see where that has been an issue, because a student attends a charter school, it's costing more money. They are, as the superintendent noted, they are public schools within the public school system. So as we look at statutory changes, you could allow a charter school, for example, that is authorized by its school district to remain a component school within the school district, and that charter school would not be an LEA because their authorizer is the local school board. For schools authorized by the SLIB board, understanding there are just 3 allowed, if we opened it up to, say, another type of authorizer, and I'm not here saying that's a good or bad thing, if we opened it up to another authorizer other than the school district, then that school logically should be its own LEA, because the school district has no oversight over that school. It has also been discussed that a school district and charter school can enter into an agreement, as Laramie does, and contracting with the charter school to provide those services. Some states allow a charter school to be an LEA only for special education purposes. And so there's a lot of different ways we can slice this, so to speak, where we could resolve some of the funding issues. I have more suggestions on the funding statute, but I don't think this is the place to do that. But however you would like to write the statute, there's many models from around the country to choose from. And I'm not talking about states like New York and California, which in my opinion are their own. It's just, they're outliers. But many rural states have charter schools, and those rural states with charter school legislation, for example, in West Virginia, allow the schools to be their own LEAs. And so I would just offer up, if you're interested in pursuing the topic, I stand in support as a resource for you, and we could certainly look at other models that states have adopted and adapt that to the Wyoming context. Because just because it works in one state doesn't necessarily mean it's going to work in Wyoming. And so I just want to suggest that there's legislative staff I could refer your staff to that have worked on this very issue. We could certainly look at statutory language from many other states, and again, however the committee chooses to proceed, I think there's ways that we can work this.
Okay, questions from the committee? Yes, go ahead.
Thank you, Mr. Chairman. And thank you for traveling all this way to be with us.
Oh, I love Wyoming.
My question is, if a charter school would become its own LEA, would it have to have a publicly elected board for governance, or where would the governance for that charter school come from?
Go ahead.
There's no charter school in the country that has a publicly elected board, but yet are still its own LEA. I can draw from an example from New Mexico, where charter schools that are their own LEA, and of the 90 charter schools, I would say half are their own LEA. They must be designated as a board of finance, and I'm not sure that occurs here in Wyoming for local school districts. But a local school board, for example, is as an LEA, would have to have, I would imagine, some sort of training or something saying that they understand school finance and how to appropriately take care of taxpayer dollars. So the elected board would really have nothing to do with becoming your own LEA, as long as the charter school absolutely followed all of the state laws and regulations regarding school finance and the appropriate use of dollars in Wyoming.
Okay, follow up?
So then who would be, what organization would be responsible for assuring that all of those regulations are followed?
Mr. Chairman and Representative Newsom, a charter school as its own LEA still needs an authorizer. I mean, that is the charter school model, where a charter school operates under an authorizer, in this case, the local school board or the SLIB. So at the end of the day, according to the charter contract regarding performance outcomes, academic performance outcomes, financial performance outcomes, governance performance outcomes, the authorizer ideally would visit that charter school at least once a year to monitor the performance of that charter school, and to assure that things are being done according to state laws and regulations. So a charter school must always have an authorizer, even though they are their own LEA. Again, that sort of charter school model is decisions made at the school level, reporting to an authorizer who, and then of course, reporting to the state because it is public funds.
Okay. Yes, Representative Conley.
Thank you, Mr. Chairman. Did I just, sorry, the sun is right in my eyes. so
That's
I'm
all right.
over here. Did I hear you just say that there was an expectation that the authorizer visit with new charter schools? And so are you familiar with, I mean, our grand compromise, if you want to call that, last year with this bill, was that it goes to SLIB, which has never done anything in relation to the administration of education in our state. But your expectation from your experience with other charters in states is that it is the authorizer's responsibility to do that oversight.
Mr. Chairman and Representative Connolly, best practice for authorizers, and again, there are many resources for authorizers around the country. Best practice would say that in order to appropriately oversee the charter school, that you would make a visit once a year to assure the charter school is following the terms of its contract. My understanding with the SLIB is that the Wyoming Department of Education, the WDE, staffs the SLIB. And so I don't know how that will work, because I want to just say, Mr. Chairman and Representative Connolly, it's a very new endeavor for Wyoming. And so your comments and questions to me are going in the right directions, because if we want to have a high-quality charter school movement, you want to assure high-quality standards, and the charter is meeting those. My understanding, Mr. Chairman and Representative Connolly, is that the WDE would provide that administrative oversight, and they would be the ones to visit the school.
Go ahead.
Just a comment that while that might seem logical, the SLIB is comprised of 5 individuals, one of whom is the superintendent of public instruction. So I honestly don't see that staffing as anything other than administrative, because that would give an undue weight to one individual who ultimately was part of the decision-making process. So that's my 2 cents about that one. So I just think that assumption is wrong.
Mr. Co-Chair?
I'll flatly disagree with that. The way it's worked so far is the SLIB has used the Department of Education to staff this issue, and I think that will continue. Strikes me as a sensible way to do it.
Mr. Chairman and Representative Connolly, I would add that all schools report to the state superintendent of public instruction at the end of the day. All schools must report to the WDE for many different aspects of running any public school. So I hear what you're saying about the state superintendent sitting on the SLIB, but it is 1 vote out of 5, and his staff is already overseeing public schools. However, Mr. Chairman and Representative Connolly, I don't pretend to know what's best here for Wyoming. I live in New Mexico. I can only say that after 25 years of charter schooling, there's many resources for you to draw from and to find out what works best for you here in Wyoming.
Okay, further questions from the committee? All right, thank you.
Thank you, Mr. Chairman.
Anyone else like to testify this time? Anyone else? Do we have anyone online? Okay. Well, I'm not sure where we go from here. I think it's gonna, LSO staff, do we have the option of entertaining a motion to put this on the table until our next meeting? Or would that, what do we need to do? There's so many things have come up, and the water's still pretty muddy in my mind anyway, and I'm not sure that we're certainly ready to have legislation ready by tomorrow even. Is that what you're thinking?
Mr. Chairman, I'm prepared to make a motion to get the LSO to draft essentially a technical correction bill. I think I know what would go in it, what to put in it. But if the committee would rather have the motion in the morning, that would work perfectly well. Because we are all getting tired.
I'd like to just hear what staff has to say about what our options are.
Yeah.
So.
Would you like to comment on that tonight, or do you want to wait till tomorrow when we've given you a little space to breathe here?
Mr. Chairman, the only thing that I would say is with the response to the LEA issue, I do think that that's a pretty high stakes issue, and it's not something that I can probably answer by tomorrow morning, looking at the research today. So on that piece, I would appreciate some latitude in a bill draft to address it. If it is the intent of the committee to assign charter schools as a local education association, or sorry, local education agency, I am getting tired. I would appreciate the latitude to research that and incorporate it in the bill draft as necessary. I don't know, sitting here today, what provisions we need to amend to accommodate that, nor do I know whether it should be just special education or for other grants that an LEA might be able to take advantage of.
Okay. Yes, go ahead.
Mr. Chairman, I think I'm ready to hear the motion and maybe put this one to bed.
Go for it.
Okay. Mr. Chairman, is it? Okay. Mr. Chairman, I will move that we ask the LSO to draft for the next, not the next committee meeting, the final committee meeting, because the next one is specialized, a technical correction bill that would include the following. In the memo from the Wyoming Department of Education, their appeal process amendment on page 2, the technical correction there, the insurance one as proposed by the department at the bottom of page 2, the annual report provision as on page 3 of their memo. With regard to the funding, I think we decided we didn't need a further amendment on that their interpretation of the law was correct, except that if the you have the 80% provision in place, make sure that we have language that makes the charter school eligible for reimbursements for transportation and special ed, and if possible, to make the correction so that the special ed funding works properly for the existing charter schools, as per the testimony we had from was the Cheyenne district, was it not? And if necessary, consult with them as to what the problem is. But we ought to be able to solve that for both of them. And I mentioned transportation and special ed. There's some other details in there, but those are the two that I remember particularly out of the Campbell decisions as being things that we need to take care of. And then with the drafting latitude that you asked for, figure a way where we can designate the again, a charter school that's under the 80% provision as an LEA in the similar manner that some other states have done it, so that we can get a model that works with both us and the feds. And if there's questions there, give us a couple of options. If there's a big policy difference between how that might be handled.
Do we have everything covered, or do we want to catch all that says other issues that may arise approved by the chairman of the co-chairman of the?
That's fine.
Because I'm not sure we know what we don't know yet, I guess.
Yeah, if we turn up with something else, we'll add that in.
Just for purposes of clarification, I don't think it's just those schools that are receiving the 80%, which are those
I'm
schools.
sorry, I cannot hear you.
I don't think it's just the schools that are receiving the 80% that are not subject to the other provisions of the law. I think the intent is any school authorized by the SLIB, correct?
Right.
Yeah. Any school authorized by the SLIP ought to be able to get the special ed and the transportation if they can do it through agreement with the local school district after being authorized. That's the preferred way to go.
Okay, are we clear enough on directions? All right, any further discussion from the committee? Sensing you're ready to vote, all in favor signify by saying aye.
Aye.
All opposed, nay. Motion's carried. Oh, I didn't see your hand till I was too late. Go ahead, Matt.
Mr. Chairman, you don't have to address this today. You can do it tomorrow in the directives, but I just wanted to address the BOCES policy options in the issue brief. I know we kind of ended that in a little awkward fashion. We took Representative Summers' bill draft request, but there were the three statutory citations that I brought up in the issue brief on the clarification. If you want to address those tomorrow, I'm not asking you to do it. I just brought those up. I just knew that we kind of ended that a little bit awkwardly. Think on it tonight. We can address that in the meeting tomorrow.
I think that was the intent, yes.
Yeah, Mr. Chairman, I just got one question for Matt. It's okay.
Yeah, go ahead.
You know, on that issue, as far as I know, there's never been a lawsuit on the existing statutory construct, correct?
Mr. Chairman, no.
Thank you.
And, Mr. Chairman.
Go ahead.
Matt, I'm going to want to propose some amendments to your draft, and I'll speak to you about that directly, but that would go beyond the draft a bit. But I can talk with Matt and develop those and then bring them to the committee in a worked out form.
Sorry, Mr. Chairman, I'm confused. Is the draft that you're talking about right now the BOCES one, or we're going?
BOCES.
So we are talking about the BOCES one and adopting Matt's recommendations? Yeah, no, I didn't think so. So actually, I'm confused about what the conversation is right now.
Yeah, Mr. Chairman, there were three policy options just to clarify the three statutes related to BOCES and the adult education program. I'm not asking you guys to take action. I just wanted to see if you wanted to take action. If so, we could do that in the meeting. I don't want to delay the evening. And I think Chairman Scott's saying he has other ideas as well, in addition to those related to the BOCES that he wants to address.
Okay. Anything else to come before the committee?